Any mention?
Please, Lordship.
Yes.
I beg to mention item number 47, my lord. I am for the petitioner.
Who's for the other side?
This is the book, Governor Mr. Karmi.
Where's the Harmi? You've taken consent?
I was looking for him, but he was not available. I think maybe he's late.
I'll inform him, Your Lordship. I'll inform him, Your Lordship.
2 weeks, yes.
Lordship.
Yes.
Much less, Lordship.
Yes.
Lordship, I beg to mention item number 41, 42 and 46.
41?
42 and 46.
Why?
Lordship, the conducting counsel has some personal difficulties, so he is not able to connect.
No objection, Your Lordship.
41, 42, 46. Okay, 2 weeks.
Okay.
Yes.
Please, Lordship, I beg to mention item number 45. The conducting counsel, Mr. S.I. is indisposed.
Who?
S.I. Omar Bane.
You've informed the other side? How long?
Lordship, keep it for 1 week. 1 week.
After 1 week, as a county council indisposed.
Much obliged.
Yes, make it quick,
Please, Lordship. Lordship, I beg to mention item number 34 and 35, Lordship. These are connected matters, Lordship.
Why does it matter?
The respondents were supposed to file the affidavit and they already filed last week, Lordship, and we need
What affidavit? Mr. Ibrahim?
bringing on record some additional documents.
So why do you want time?
Lordship,
You filed this last week.
yes, Lordship. They filed on Thursday, Lordship. So we received it on.
Matter, I don't want to keep it.
and we just got to see it today, Lordship. So
435.
subject to your Lordship convenience, 2 weeks.
A submitted affidavit been filed on behalf of the respondents. Sorry. The learned counsel submits that they have just received a copy of the affidavit filed by the respondent. Prays the matter be adjourned for today. Only this is a matter up to 1 week. Yes.
Highly obliged.
Your Lordship, I beg to mention item number 40. Item number 40.
Yes.
Your Lordship, the conducting counsel is out of station.
Who? Mr. Nath.
Shri Echanath.
Other side?
No objection.
Yes, 1 week. Yes.
Obliged. Item number 1.
Yes, Mr.
May I please, Your Lordship? Lordship, this is, with regard to the date of birth, my lord. I was appointed in the year 1998. White appointment order dated
88 or 98?
88, my lord. 1988. White appointment order dated 3/3/1988, my lord. While I was appointed as motor mechanic at William Nagar, my lord, fire station. I was 7 pass dropout. My age was at that time was 21 years, my lord.
When you dropped out?
My lord, 7 pass dropout.
You 21 years, 7 plus 7?
My lord, I was dropout in the year 1979, my lord.
Okay.
Then, my lord, I was appointed.
What was the age that time?
21, my lord.
21 years, 79.
No, my lord. In 1979, my age was 12 years, my lord, as per my school record.
Okay.
In 1988, my age was 21. I was appointed. So after my appointment, my lord, I was appointed as contractual appointment. Then my service was regularized, my lord. My lord, I was during my service career, I was on the impression that my actual and correct date of birth was recorded as per my school certificate.
The open service book for you?
Yes, my lord.
What is the record in your service book?
In all the records, my actual and correct date of birth recorded as 24th January 1967. In the biodata and service book, only one record which is in bracket, my lord. That is 1964. And the respondent authorities holding that 1964 as my date of birth retired me, my lord, superannuated me. in the year on white impugn order dated
So
29/6.
what do you want now? Let's see your prayer.
My lord, I won, my lord, presently, my lord. My actual and correct retirement will be, my lord, in the year 2025, my lord.
How will be 25, 67?
My lord, 67, my lord.
January 67, so 58 plus 67?
My lord, no, my lord. My lord,
Okay, January 25.
my lord, yes, my lord. Supposed to be in 2025, my lord. It's still 2 years, my lord. 2 years service remain, my lord. They have, I have filed my representation after receiving the notice. They have issued the notice.
Have they rejected it?
They have not rejected, my lord. They just simply inform me that your representation is under consideration. Then they have issued the impugn order.
Where's the impugn order?
My lord, at page 34, my lord, Annex 10, my lord.
Yes.
May I read, my lord?
Yes.
Reference this office memorandum so-and-so dated 10/5/2022, mechanic Shoidur Rahman Mullah of substation FNES Mendipathar, North Garo Hills, is hereby released from government service to go on superannuation pension with effect from 36/2022 AN on attaining 58 years of age with a service career of 34 years, 2 months, 29 days as per FR 57C of Meghalaya FR and SR 1984, my lord. That is the impugn order, my lord. I filed representation before that, my lord. They have not disposed, my lord.
You all been paid a pension now?
No, my lord. The matter was sent to the my lord, Lok Adalat. When I approached them, the respondent authorities, they assured me your matter is sent for Lok Adalat for
Okay,
settlement.
Take notice.
Call for the records, my lord, at least, my lord. In all my service.
Let them file affidavit. Yes.
Yes, ma'am.
Heard Mr. S.K. Hassan, Commissioner. Issue notice MS item
125, Your Lordship.
Except notice GE number 5. Mr. Karmal Plang is present and accept on behalf of spot number 6. Yes, sir. Let's after 3 weeks for instructions and affidavit. Yes.
My
Obliged.
I'll oblige.
Item number 2.
Wait, please. Lordship, kindly see this tender is in one part only, because whosoever will qualify in the technical bid, he will get the contract, because it's not for quantity, it's a supply order which we will place time to time, and in this is the format which we have followed. Kindly see why we have followed this format and what is the requirement, my lord. Kindly see the tender which we have placed before your lordship.
I mean, no, one thing, Mr. Advocate General,
yes,
is that
lordship.
Financial bid might not be like for the entire volume of the contract, but
Yes.
financial bid might be for the item-wise
There is
materials that they will supply.
No, there is no item-wise supply, my lord. What we say is that as per Schedule 2, which was pointed out by the petitioner, my lord, as per Schedule 2, we will place the order time to time. And this price is fixed by central government, that on that price only you will supply. That price cannot be.
There's no negotiation on
There
price.
is no negotiation, anything, my lord. That the problem in, because if you lordship will
Even
see
if
the
there's escalation also, he has
nothing,
to bear.
nothing.
He'll have to bear the brunt.
Everything for 5 years. For 5 years, and in this way, because I checked from the department, similar contracts have been agreement have been entered in past also with all those who have qualified technical bids, my lord. This is the, if your lordship will see why this is a kind of, and I have seen the contracts which have been annexed by my friend. Those are of 2015, where fixed quantity of item was mentioned. 2015, my lord, NFSSA, National Food Security Act, came recently only, my lord, in 2017. And if your lordship will see the tender document also, it is clear from the tender document also, my lord. Kindly see the tender document in this regard. Because I checked the scheme also, your lordship, kindly see section 4 which my friend has pointed. Space, your lordship will find at page 99.
Yes.
Section 4, subject to such schemes as may be framed by the central government, every pregnant woman and lactating woman mother shall be entitled to meal free of charge during pregnancy and 6 months after the childbirth through the local Anganwadi, so as to meet the nutritional standard specified in Schedule 2. So nutritional standard has to be as per Schedule 2, my lord. There is no confusion, my lord. Now what has happened, my lord? My friend has pointed out the schedule has been modified. If your lordship will see the schedule which is originally appended with the Act at page 112.
Yes.
This is the schedule. If your lordship will see, the children 6 months to 3 years, take home ration, calorie 500 and protein 12 to 15. This is the old schedule which was there, my lord.
Yes.
Now this schedule came to be amended and which has been pointed out, which is at page 118, my lord. 117. It starts from 117. And if your lordship will see schedule 2 in the middle of the page, section 4A and 5.1 and 6. Person's age group of physiological. And then your lordship will see.
Where are you reading from?
Page 117, my lord.
4A, 5.1 and 6.
Yes,
So this is
yes.
standards specified in the table below.
Yes, my lord. And
Okay.
table below is 118, my lord.
Right.
Table,
1 year 6.
Yes, now your lordship will find that there is a change in the table. Schedule 2 has been altered slightly.
Six months to 3 years.
Yes, so then there change in the schedule which we are going to follow, because we will get grain only when we follow the schedule 2, the amended schedule.
Now we'll just come now to page 112.
Yes,
Children
Lord.
6 months to 3 years.
Yes, your lordship will see 6 months to 3 years, and in new schedule your lordship will find the
1 year up to 3 years.
one, and the protein has also been your lordship will see protein has been less now, because earlier it was up to 5 years, so protein was more, but the protein requirement has been increased for the up to 1 to 3 years, and you will also find so these changes have been, these are the statutory schedule which we are bound to follow. Even supplier is bound to follow, my lord. There is no quarrel or no, and we will
what
go.
does the tender document specify?
Yes, your lordship, earlier schedule, but tender document.
Have you issued a corrigendum?
Yes, your lordship, tender document itself empowers us to do that, my lord. That is there. If I can take your lordship to tender document, my lord.
Okay.
Your lordship will see the requirement, 2-3 clauses only. The ISI certificate, financial statement. Now, time schedule is also there for submitting the bid, my lord. Page 52, your lordship will find.
Yes.
This is the schedule, my lord, and the Roman 1, if your lordship will see, of that after the schedule, my lord, one more aspect may kindly be taken note of. If your lordship will see that bid, the price rate per day beneficiary is also fixed by Government of India.
I don't know where reading here.
I'm sorry, page 52. Page 52.
Okay, there's time schedules, price details. Okay, what Roman?
I want to read, my lord, first price detail. Your lordship will see the price detail, below that cost norms.
Yes.
By Government of India letter so and so as follows. This is the cost norm. Now, one, your lordship will find after the table, the bidder must state clearly as to whether they are willing to undertake the job as per terms and condition, as because the entire cost fixation of the work being governed by adherence to the strict guidelines as laid down by norms of Government of India, Ministry of so and so, dated so and so.
Yes.
This is the price, my lord. One more, after going through the chart at page 53, there is some typo error also which we are correcting. Now, your lordship will say, see page 59. Sorry, page 54. Page 54. Your lordship will kindly see page clause 6.
The manufacturer.
The manufacturer should accept the rate for each category of beneficiary as per the ceiling fixed by Government of India. For each category of beneficiary per day, the bidder should submit the acceptance letter. And then 7, your lordship will see quantity of micronutrients, fortified energy dense food per day should not be less than 100 grams for all categories of beneficiary, and should meet the prescribed nutritional norm within the cost norm.
Okay.
And then your lordship will see the page 56. Other terms of EOI.
Yes.
At any time prior to the deadline for submission of bids, purchaser may, for any reason, whether at its own initiative or in response to clarification, request by the modify the bidding document by amendment. So this bidding document can be modified at the stage of clarification, my lord.
Then you file Dr. Mozika for clarification.
And he should participate, and we will clarify, we will follow. And then your Lordship will also see this amendment to be D also. Director Social Welfare Meghalaya shall be at liberty to make amendment of modification to be bearing document at any point of time before the date fixed for submission of EOI if he feels so it is necessary on his own motion or in response to request reasonably made by a prospective.
When is the last date of
Your Lordship is 8th September. That schedule your Lordship will find at page 52.
Price along with the price details.
Your Lordship, yes, time schedule 52 at the top of the page, your Lordship, is that e-publishing is 18th September, start time is 5 am. Then your Lordship, end date is 5/9, my Lord. And then pre-bid meeting is that no pre-bid meeting by 6/9 they can submit queries, my Lord.
Yes.
And so therefore till 8/9, my Lord. Because this is meant for supply of children, my Lord, and
that's
the
why
price
court doesn't want to.
Yes, your Lordship. And if my friend has any issue,
matters which where
yeah, I bow down. I understand, your Lordship. And
my Lord, may I point out few things, my Lord?
Well, let him finish. Yes.
Yes, my Lord. So this is one aspect of the matter, my Lord. Now, what my friend is saying that we have the contract, which the price is, your Lordship, they have to give the acceptance letter, they have to give the performance bank guarantee, and they have to meet the point norms also. Because point norms is also required, and if your Lordship, I can take to the point norms also, those point norms are properly charted out, properly discussed, and properly considered, my Lord. So if I can show, my Lord, those point norms also, there is nothing wrong with those point norms, which my friend said that. Because what we are giving it that you should have manufacturing license, you should have the experience of providing this. I've got the case laws also supporting this, but that occasion.
Point norms. This
Your Lordship will see. Yes, please. Your Lordship will see.
Now, what do you have to say with point? How do you say that it is just and fair? Because
yes.
With regard to.
Yeah, kindly see the point norms.
That 8 and 9, they agree with that only.
Yes, your Lordship. Now, if your Lordship will see it, factory in northeastern states.
ISI certificate.
Now, if your Lordship will see that minimum points required for qualification in the EOI is 85%.
Yes.
85. Now, kindly see first manufacturing license, 10 points. So you should have manufacturing license. FSSI requirement, you should have 10 points.
No, what Dr. Muzika is eyeing that day is that suppose everything remaining equal, they can never get this other 15 points. Because they don't have factory in Northeast. So like
10% is gone.
That means 10 points gone. They won't get additional 10 points.
Yes.
Plus that 5 points. So even if they all get this 10, 30, 45,
85. It will reach to 85 million.
85,
and he will qualify it.
But then the other one's preference clause, the 10 points admit.
Here I am making the statement that those who will get 85% will get the contract for supply.
They will all get.
They will all get.
Whosoever
will get 85 will get the contract. That is what I wanted to show. These are the contracts which we have given in past also.
So you're not looking at one contractor.
We are not going to give all multiple, because this is a supply for 5 years, my Lord. Who is going?
So at that point of time, when you say, okay, we qualified, how do you pick and choose who gets the
so therefore now then we will call them whether who is in position to fortify grain. There are various types of, as per schedule, there are various type of requirements.
But then that thing, Ms. Sapke General, makes it very open-ended. No, suppose now A, B, and C, your three tenders, you qualify, correct?
Yes.
For supply of some foods, food stuff and all.
Yes,
okay, we have this requirement. Now suppose you already qualified. Now who gets what quantity? How do you arrive at that?
Now that is,
you give him to supply 1 kilo and give him 100 kilos.
If your Lordship will see what has happened at that stage, what we do is that what the practice is being followed, that like food grain mix is there. There are various items in schedule.
No, we're not talking about that. So how will you apportion?
And I will invite all of them to tell me who is in position to supply in 1 month or 2 months, my Lord, or 3 months, because these things are dynamic. Somebody will have stock, some will have no stock, my Lord. So therefore, in that stage, my Lord, there is no requirement.
So your statement is that submission at the bar is that whoever qualifies technical bid will be a successful tenderer.
That is my statement. Your Lordship may kindly record.
My Lord,
and giving preference, my Lord, giving preference is, my friend is saying, giving preference to those who are working, having experience of working, my Lord, with utmost humility, my Lord. This requirement in my humble submission, is not erroneous or arbitrary or actuated with malafide. Because this, my lord, your lordship has seen,
gone by the act.
because all by the FCI godowns are in Guwahati. They will supply the material in Guwahati. That those material or food grains are notified or fortified in far off places. My lord, transportation cost and all those factors have to be taken account. So experience is a factor, and these kind of clauses have never been. My lord, I have those case laws. I can cite those case laws.
Let's hear Dr. Mojika.
My lord, if that statement, I'll pray lordship will record that.
Of course,
all those who score 85, because that means the preference clause is overwritten, my lord. That is become redundant in view of the submissions of the learned advocate general, my lord.
No, he cannot override. His submission is this.
My lord, there is a preference clause, my lord.
Technical bid will be considered will stand qualified.
My lord, our apprehension was, my lord, there is a preference clause, my lord. Lordship will see that at.
Before my lord, my learned friend, one more point. Whether he has participated in the bid or not. Who is he? What is his locus, my lord? Because if he is not participating, he is a rival. His purpose is to stall the tendering process. His purpose, because if he has all these issues,
no, will not stall the process.
And what
that will tell you, there's no stall the
and
process.
One, my lord,
if anything to iron out, they can be ironed out before. Now is the 4th. You iron out by 7th and finish.
At this stage, my lord, at this stage, when he has not raised all these objections in the pre-bid meeting, the bid document gives him
pre-bid
right.
meeting's over?
No, it's on 8th September. 8th September is 6.
My lord, what kind of submissions are made, my lord? Lordship kindly come to page 52, my lord.
He can raise all these grievances. And if he has got grievances, he could have raised those grievances.
Kindly come to page 52, my lord.
So he could have raised, my lord. It is basically rivalry which is there.
Can I serial number 3, lordship? In the table, no pre-bid meeting to be submitted latest by so and so. What is the meaning of this sentence, my lord? I was trying to understand the meaning of this sentence, my lord. No pre-bid meeting to be submitted.
It's a wrong, it's typo.
Typo, my lord, by 6-9. But they are saying pre-bid meeting is a column is also there.
My lord, it says no pre-bid to be submitted.
And bidders may
latest by 6/9/23, my lord.
Bidders may send the queries by email also.
You send your queries by email by today.
My lord, we don't have any queries, my lord. We are laying direct challenge, my lord, that the schedule of the Food Safety Act has not been incorporated.
Have you cast your bid?
My lord, I am going to cast my bid.
Then you cast and then you file, and those are clarifications that you should raise before the. That is what is that? That is at. Page 54.
And my lord will kindly see, bidders may send queries through email at so and so till 21/8/23, my lord, and the tender was floated on 18th, my lord. 18/8.
My lord,
one second.
My statement may be recorded that they can send all clarification. Why did not they send the clarification if they were having the clarification on 18th?
My lord, one more aspect, my lord, which is a hindrance on my path, my lord, is the criteria of only 3 years, my lord. 22-23 is not counted, my lord.
No, but that is correct.
My lord, there is no
accounts won't close now.
My lord, accounts are not necessary, my lord. So kindly come to page 49, my lord, at clause 6.
Accounts won't close now, so
my lord, accounts are not necessary, my lord.
Yes.
Lordship will see clause 6, my lord. Documents relating to past experience of supply of micronutrient so and so of rupees 10 crore each in the last 3 years. That is, what is required is, my lord, order copy and work completion certificate to be enclosed, my lord.
Yes.
My lord, 22-23 is over on 31st March, my lord. We are in September right now, my lord.
What is for the year 21-22 financial year?
My lord, 22-23 is complete, my lord. The financial year is complete. Why the experience of 22-23 will not be counted, my lord?
Yes, why 2020 not one?
Your lordship, the process
if it's only for copy and work completion.
Your lordship, lordship,
you're not asking for financial details. You're not asking for audited, chartered accountant statements.
The issue is, my lord. The issue is, my lord. We have to float the tender. The tender has to be floated in time, my lord. Now, if I say that just because he is meeting, for example, his grievance is that now he is going to meet this year. Somebody will come say that I am meeting it now. Why not in June?
No, listen. It's like this. Order copy and work completion certificate. They're not asking for financial details. The thing is that now, if you see in the last 3 years, you can't qualify it by saying 2019-20 because logically it'll be taken 21-22 or
that is 31st March 22.
2021.
Yeah, my lord, 3 years. If what his grievance is that if I have said, my lord, 20, because we have to give sufficient time for getting the certificate also, my lord. On 31st March, on 1st April, no government.
You raise a query. We will not pass the order.
My lord, raising query, my lord. My lord will kindly see the.
This court doesn't want.
My lord,
it involves ICDS.
We want.
You see the, you see the good that this ICS program is doing, especially if there's any hiccup in the, supply.
My lord, nor we want, my lord. We also don't want to frustrate or derail the tendering process, my lord.
Where this nutritional program really helping. And so the thing is that if there's some manifest error, or illegality, yes. But the thing is that if the price is already fixed by central government,
price is not fixed by central government. That is the ceiling price, my lord.
The ceiling price.
Yes. Ceiling price, my lord.
For 5 years. For 5 years, they have to give the undertaking for 5 years.
See, ceiling price has been fixed. Now, if you can procure it
and can you go and bid
the profit margin?
My lord, there is no financial bid. There is no question of
financial bid if the ceiling price is given. That
this is a fixed contract.
You're saying, okay, fine, we want this camera. We want a supply of cameras, like the maximum price is 3,000, and those who have the technical aspects of the camera, it's as per the requirements. You all qualify. We need 10 cameras, by 2 from you. So the play the joints.
My lord, they'll purchase the old schedule material, my lord. 12 to 15 grams, my lord.
You raise the queries because.
No, my lord, in my humble submission, these are not the question of queries, my lord.
Then what is the court to do, Dr. Mozika?
Court will direct them. I am not asking for stay, my lord. Court will direct them to amend the schedule, my lord, number 1, incorporate 22, 23, my lord. There is no logic, no rationale for that, my lord. The 22, 23 will not be counted.
You have to show that, this incorporation of only this year's 2022 is to favor someone.
My lord, in my humble submission, that will not be necessary, my lord. My lord, pure logic goes, my lord, when the last 3 years will mean when 22, 23 is over, my lord, that year should be included, my lord.
Okay, take down. Yes, the present petition.
Only one more submission, my lord.
Yes.
A more or less similar tender was floated by the Assam government, my lord. Same company challenged it and they withdrawn.
Let's see the order.
They realized, my lord, the mistake.
There is no order, nothing, my lord.
They realized that their schedule is wrong, my lord.
There is nothing, my lord.
The schedule has to be, the schedule has to be as per the amended schedule. But there are no two questions.
What is stopping them from issuing a corrigendum today also, my lord?
We'll do it. You go and clarify. You can't dictate us to sue today, tomorrow.
I'm not dictating to him.
The private party is coming. Private party is coming and saying that you do it.
I'm not dictating government. I'm coming to this honorable court, my lord. I'm invoking Article 226 that this is against the statute, my lord.
Give me what have you got. At least yes, I should have the copy.
Nothing in the order.
My lord, kindly, my lord, I'm not asking for staying anything, my lord.
See, there's no question of stay also.
But that was
okay. My lord, the order is the present petition has been filed challenging the certain terms of and conditions of the expression of interest floated by the Director of Social Welfare, Director of Social Welfare, Meghalaya Shillong. Stop. The contention of the writ petitioner is that the said terms militate against the statutory provisions of the National Food Security Act 2013 and General Financial Rules 2017. Stop. Next paragraph. Dr. N. Mozika, the counsel for the petitioner, submits that the tender, the EOI, dated 18/8/2023, on the face of it is faulty, inasmuch as the schedule, which is given there in the EOI, refers to a schedule which has since been amended by This is by the notification dated 25th January 2023 with regard to the prescription of nutritional standards. Stop. The other grievance as put up by the council, by the petitioner, is that with regard to the qualification points, which page is that?
6 we got at page.
At page?
Is 49.
Qualification points?
Yes,
No, page.
yes,
58.
page 49.
58.
Yes.
With regard to qualification points, which he submits, has been tailor-made to favor.
My lord, I have not said tailor-made, my lord. What I have said is
Has been
there's no
which he submits has been weighed heavily in favor of suppliers or bidders who have factories in northeastern states or who have supplied micronutrient energy dense food to the department's northeastern state for the last 3 financial years. It is submitted that 85 points for qualification in the UI has been laid on criteria, and 15 points of the 100 possible points, and 15 points of the 100 possible points being in favor of locally situated bidders, bidders such as the writ petitioner have been put to a great disadvantage to qualify for the said technical bid. Stop. Another contention that has been raised is with regard to what's the other one you raised?
well, 3 years, my lord. That is at page.
Yes, with regard to the requirement of
Clause 6, page 49.
is with regard to clause 6 of the UI, which has mandated that documents relating to past experience of supply of micronutrient fortified dense food in the social welfare department of rupees 10 crores each in the past 3 years, that is 2009-20, 2020-21, and 21-22, has been given. Stop. It is submitted that at present the financial year 22-23 is already over, and as such there is no basis or logic in the fixation of the last 3 years to include 2019-20. Stop. That is all. No, anything else?
My lord, clause 11, preference clause, my lord.
Where is that?
Page 50, my lord.
50?
50.
Page 50.
50.
Yes. Next, a grievance has also been put up with regard to clause 11 of the EOI, which gives preference to the bidders, qualified bidders having factories situated in Meghalaya. In this backdrop, he finally submits.
Submissions, my lord.
Yes.
One was that there is no product description in the entire tender, my lord. I pointed out, my lord, how much it should be the wheat, how much should be the rice.
Further submissions are that there has been no product description of the materials to be supplied, and also,
my lord, there are no price bid, no financial bids,
and also that there is only that the entire UI consists of a single bid system, that is the technical bid. Stop. In this backdrop, he submits the EOI being faulty. is liable to be, formal respondents are liable to be directed to retract and recall and correct the same in accordance with the prescription of the Food Security Act, and as also, of course, and in accordance with law. So, next paragraph, Mr. Amit Kumar, Learned Advocate General for the appearing for the respondents, has at the outset submitted that the absence of financial bid is due to the fact that the maximum price of the materials is as per the rate fixed by the Government of India, and as such, all bidders who qualify or who pass a technical bid shall automatically stand qualified. Stop. It is further submitted that as the tentative period is for 5 years, and the requirements are not been fixed as yet. Right?
Yes, sir.
And the requirements being dynamic.
And requirements will be followed as per the schedule.
Yes. And the requirements being dynamic, which will be as per the requirements. The financial bid will not be feasible, and the suppliers who qualify, depending on the capacity, will be awarded suitable work orders. So, Learned calculations have already taken this code to the clause
that is at page
price details.
Yes, my lord. That is that price detail. Price is 52, page 52, my lord. Price details at page 52.
It's also taken this code to the price details, more specifically at clause 1 thereof, which clause 1 of which contains a condition with regard to cost fixation that the bidders must be willing to adhere to. Stop.
Then fix it.
1 second.
Clause 6.
Terms of EY. Yes, Learned Advocate General has then referred to the other terms of UI, Roman 2 at Roman 2 A, where it's been provided that at any time prior to the deadline for submission of bids, the purchaser for any reason, whether it is own initiative or response to clarification requested by prospective bidder, modify the bidding documents by amendment. He submits that this clause on a clarification being sought by the bidders, the respondents are enabled to modify the bidding documents or document to modify the bidding documents by amendment. He also has referred to clause D with regard to amendment bidding documents in response to a request reasonably made by prospective bidder or bidders. So it has also been stated at the bar by Learned that any amendments that have been brought forward, that have been brought in the Food Security Act with regard to the schedule, will suitably be inserted or will be inserted into the modified EOI, and that if the bidder has any grievances, the same can be addressed to the respondents who shall take it up in right earnest. Next paragraph. Having heard the counsel of the parties, it is seen that the grievance of the writ petitioner centered around the fact that the grievance writ petitioner at this stage should and can be addressed by the respondents, as it involves a matter of grave importance, which involves the food security of children and mothers. This court is not inclined to issue any interim orders for the suspension of the tender process, but however directs the writ petitioner to prefer a representation on the grievances as made out in the writ petition before the respondents, before the what is the last date?
21st
the last
August.
date opening of bids, which has been scheduled
To be open
for
at
8/9/2023. Stop. The next paragraph, the writ petitioner shall prefer the said representation within a period of now 2 days of 4th by the after tomorrow, 4th is 6th by the after tomorrow, and the matter, and on 7 thereof, the respondent shall dispose of the same positively. Yes. With the above direction, this writ petition stands disposed of.
But one statement of the Advocate General that whoever qualifies
That's
85
already said.
That is
that has not been recorded.
So,
my lord.
my lord, there is no.
My lord, the statement was my lord.
Why I say, my lord, because the.
My lord, the statement was my lord.
I have said.
My lord, he cannot retract now. My lord,
I'm not retracting.
I can
Why
play the
I'm not
YouTube video what
retracting?
Learned
But the
Advocate General
question
said,
is, my lord,
Learned
I'm
Advocate
questioning the
General said-
locus. I'm all questioning. I'm questioning the locus also, my lord. I'm questioning.
Technical bid will stand qualified. That's already
Good,
there.
that's all. That's
Qualified,
all.
he'll be given the contract. My lord. That was the submission, my lord.
He qualified.
But the submission
Qualified
was,
and
my
he
lord.
Yes, you stand qualified and be given work orders.
That's all.
Work order.
That's all.
Item number 3.
But only thing, my lord, he has no locus in law to challenge this.
Doesn't matter. See, it's a matter involving if
There is
there's
not
something
real,
wrong, if
my
there's
lord,
something
with
wrong
respect-
even in your
my lord,
contract,
that's why
Mr.
I-
Advocate General, if it's flagged or brought to the notice of the court, the
Or
court,
he
the
can
court
no he
by
can
all
bring
purposes
Nah,
thing
my lord,
will interfere.
before approaching this honorable court he should have approached the authority, my lord. That is the process which we has to be
You
followed.
don't allow.
He should have approached.
You don't
He
allow
did
me
not.
to approach the authorities,
He
my
wanted
lord.
to
There are
this
clauses, my lord.
ambush practice. This
My
is
lord,
ambush
my lord, the
practice.
sentence says no pre-bid to be submitted by 6/9, my lord. What is the meaning?
Right.
My lord. But the matter is disposed of. My lord.
Dispose of it. Any grievance, you can come again. That's
Yeah, we'll come back.
This definitely.
Yes.
Item number 3.
What is this?
Your Lordship. My Lord, this is, my Lord, pertaining to a Weybridge, Your Lordships. Now, my Lord, briefly, if I can narrate, my Lord, Weybridge, Your Lordships. I'm just coming back to it. Now, Lordship is aware, my Lord, under the Motor Vehicle Acts, Section 114, my Lord, state government are authorized, my Lord, to use such women devices, Your Lordships,
No,
for the purpose, my Lord. Those things are
come to.
no, my Lord, I'm
the
just
matter.
coming because my endeavor, my Lord, because these are ultimately what happened, my Lord. That was a statutory contract. So, my Lord, till the first part of 2009, Your Lordship, government has a policy, sort of a policy decision, my Lord, how they use in certain situation, government will use certain situation, my Lord, they will take help from the private parties by entering into a list. Now, in 2009, my Lord, they framed the rules, Your Lordship, in pursuant to the power 138 of Motor Vehicles Act. Now, my Lord, that rule I have annexed, Your Lordships, at page 25, my Lord. We start from 24, my Lord, and 20 is a short rule, my Lord. Only the relevant paragraph I will read out. 25, my Lord. 9 December 2009.
Yes.
The Lordship come to Rule 3 is regarding installation. The government may install and maintain by itself
Yes.
as many weighbridge for the purpose of Section 144 of the Act on such places as it may think necessary, or may allow any private person, body or person, company, organization to install and maintain such weighbridges on payment of lease amount to be determined in each by the government after calling tender. So two options were available, government of its own or can be by a private party, but that has to be done through tender, Your Lordships. Now, my Lord, if I can take Your Lordships to the next page. Now, 4 and 5, my Lord, what are the requirements for a private party to be eligible to apply for permissions? Now, my Lord, we will kindly come to 5. Permission of weighbridge at satisfaction of Commissioner of Transport. In considering the grant of permission, the Commissioner of Transport should satisfy himself that the proposed place installing the operation of the weighbridge, National Highway, State PW route should fulfill the following. My Lord, these are the criteria required to be fulfilled. This is for a private person again, my Lord. Now, my Lord, 6. Commissioner of Transport to forward the application to the Secretary Transport Department after satisfying himself that the application is complete and meets the requirement as laid down in the aforesaid. Transport shall forward the application with all required information to the Secretary for issue of permission. So this is the procedure, my Lord. Now, my Lord, 7, because my grievance is here. Renewal of permission.
Yes.
Any permission referred to, my lord, the rules shall be renewable every 3 years on such permission, and no such permission shall be granted renewed unless the proposal for the grant of renewal of permission, as the case may be, is accompanied by certificate issued by such and such, such and such. So, my lord, what it is contemplating, your lordships, under the rules, my lord, normally the permission is for 3 years and on expiry eligible for, my lord, another 3 years. After every 3 years, so it is not saying 1 year, 2 years, my lord. So what it is, my lord, normally initially the permission is 3 years, so my lord, renewal also has to be for 3 years, my lord. This is the thing. Now what happened, my lord, in 2016, government floated a tender. Government floated a tender, my lord, amongst other places, my lord, in a place called, my lord, Amsarin. Amsarin. A place called, my lord, Amsarin in Juai Dauki Road. My lord, they proposed to set up a weighbridge. They proposed to, my lord, from the private parties invited tender, my lord, for setting up weighbridges. Now, your lordship, keep it in mind, my lord, this is not a small project, huge project, because this comprise of the weighbridge, huge chunk of land, related infrastructure, staff quarters, and subsequently, my lord, this initially, though it was a weighbridge, subsequently it has been made into a integrated check gate cum weighbridge. So, my lord, staff quarters, everything. So, huge investment, my lord. Electronic devices, electronic records, all these things are there. So, person who is doing it will have to make everything at his cost, my lord. Huge amount is involved. So, my lord, I participate.
Huge amounts earn also. Anyway, that's besides the point. Yes.
So, my lord, I made a huge. Yes. I was found to be, my lord, the suitable tender. Yeah, right. It was settled with me. I made the investment, build up the, set up the weighbridge, staff quarter, levies, all kind of infrastructures, your lordship, and they made a formal agreement with me. Now, your lordship, that agreement, where's the page? First agreement. First agreement. My lord, that is at page 34.
Yes.
Lordship. Now, my lord, this is made, my lord, 7th day of December 2017. The governor of Meghalaya, represented by the Commissioner of Transport, government of Meghalaya, Shillong, the first party, and the second party is me, your lordships.
Okay.
Now, my lord, this is clearly saying, my lord, and where is the government?
Where is the term?
Terms, my lord. I'm just coming, your lordships. And my lord, lordship can come to the next page.
The other situation.
Next page about the amount, your lordships.
No, amount, forget the amount. Where's
my lord, next, lordship will come to 36.
Yes.
36. The license shall remain valid for a period of 3 years. Okay, my lord, this is because what I am trying to impress, my lord, this is as per the, because I want to say this is a not say, my lord, this is a statutory contract, my lord, not a normal contract. This is as per the rules. 3 years, which is in accordance with the provision of Rule 7 of the Meghalaya Installation Regulation Maintenance such and such, and will be subjected to revalidation on a yearly basis as to the full payment of annual fees and 50% share of the total wearment fees, which shall be examined by the Commissioner.
What happened after this?
Now, my lord, this yearly validation, that means it is for 3 years, but they will look into it, my lord, whether, my lord, I am complying with the terms and conditions, my lord. If not, my lord, they will cancel it. That is the meaning, but has to be for 3 years, your lordships. Now, my lord, next your lordship will come. The agreement shall commence on 7th day of December 2017 and up to 6th December 2020, 3 years. The agreement shall expire on 6th December 2020 on completion of period of 3 years with effect from suggestion unless and until the license stands renewed in terms and conditions as stated in clause 1 above and fixed by the government from time to time subject to such and such. Now, your lordship, renewal clause, your lordship, if you can take my lord. That is at page 40. The application, clause 17, my lord, the application for renewal of the license, if any, shall be made at least 2 months before the expiry of the license in writing. In absence of the consent in writing, renewal of the first party, the agreement shall terminate exactly after 1 year with the flags of time. So that was the situation. Admittedly, my lord, this is for 3 years. In December 2020, it expired, your lordships. Now, what happened, my lord? In time, I have filed my applications for renewal, along with the requisite fees and all. Now, in the meantime, what happened, your lordship will recall those days, 2021, your lordships. The restriction, my lord, induced by COVID, your lordships, it was there. Now, during that period, they have granted me an extension, And they said you made it because things were not working on 50% payment, you carry on. So hardly there was anything, my lord. I continued. But at the same time, my lord, since I have applied for a renewal, it was not coming. I approached this court, filed an application that I have applied for renewal, but it's not coming. Now, my lord, what happened to this application? They came up with an affidavit. They filed a government an affidavit. They said, yes, we need to look into it. In fact, we are doing it to others. Come to us, we'll look into it, my lord. That affidavit, I'll take your lordships. Page 45. Well, the relevant paragraph is at page 5. Paragraph 5, my lord. Page 46. Well, I'll just read it. The statements made in para 8 are correct with regard to the mention about the provision of the rule. Petitioner is advised to approach the Transport Department for favorable renewal, which shall be considered taking in view the provision of Rule 7 of the Meghalaya installation, such and such. Point number 2 of the Meghalaya State Policy of the year 2018. And after proper scrutiny of records and documents related to payments of all government dues, in fact, it is also stated recently that government has accepted the petition of extension of lease agreement in respect of Majai Weybridge, East Khazil districts. So they said we have done it to others. We'll look into it definitely as per the rules and we'll consider it. So my lord has disposed of that matter. Your lordship's order is at page 50, my lord, annexure 8. Maybe I can read it, my lord. That is dated 9/5/2022. Well, if I can read. The batch of writ petition have been filed for renewal and the continuation of the existing agreement between the state petitioner running the Weybridge. It appears that the petitioner is still running the Weybridges, and as part of the affidavit, the state responded as indicated in paragraph 5, the renewal of petitioner license will be considered in the event that an appropriate application is submitted before the state respondent. In view of the circumstances, the affidavit as placed, Mr. Such and Such, London Senior Counsel for the petitioner submits the writ petitioner can be closed. Accordingly, it is directed the writ petitioner to approach the state respondent with an appropriate application within a week, which is to be considered expeditiously, preferably within a period of 1 month from the date of receipt of the certified copy. Now, my lord, your lordship, I have placed this order. Now, the next order, your lordships, they made a searching inquiry and then they passed this order, 5200, Annexure 9, dated 30th May 2022. The Honorable High Court of Meghalaya, while passing the judgment in such and such, these are the, my lord, batch of petitions were dismissed, my lord, decided by your lordships, has directed the petitioner to approach the state respondent with an appropriate application within a week, which is to be considered expeditiously, preferably with the period of 1 month from the date of receipt of the certified copy. So order. The Office of the Commissioner of Transport thereafter received the copy from the petitioner on such and such date, which has been processed and forwarded in original to the Transport Department on such and such, such and such, such and this, for further action. Therefore, in order to comply with the direction contained in the Honorable High Court's order, the petitioner is hereby directed to pay a renewal fee such and such.
And the court never directed them for renewal. How would this order say that is very strange.
Lordship.
This is actually, that means collusion.
Therefore, in order to comply with the direction contained in the Honorable High Court order, petitioner is hereby directed to. No, well, here what these renewal fees was already paid.
So where order comply direction contained?
There was no direction, my lord. There was absolutely no direction.
Lordship, my lord, this is their order. It's not.
Exactly.
They have written.
My order is wrong. I am admitting it.
Anyway.
Lordship. Now what happened? My lord, yes. This renewal application, so far this renewal was concerned, my lord, this was already filed, your lordships, when it came. But then again, they should not have asked. They have again asked me, my lord, to file the renewal fees and application. I have filed. I have complied, your lordship. Now, my lord, next page is the charge 250 rupees, your lordship. Now, my lord, they ultimately made an agreement with me, lordship. Start at page 55. The agreement is made.
An agreement.
Lordship, they made an agreement. The agreement is made on 1st day of June 2020 to the Governor of Meghalaya, my lord. The relevant part, your lordship, will come. Lordships. My lord, the terms and conditions starts from page 58. But only thing, my lord, one clarification here.
Where the term?
Terms and conditions starts from page 50.
For the term from
52
to
Lordship.
25.
25. 3 years.
That?
3 years. Huh? I just read it. The license take effect from 1st June 2022.
Please give the
58.
58.
Page 58. Terms condition number 1.
Okay, yes. Okay.
Lordship.
Page 58.
The license takes effect on 1st June 2022 and shall remain valid for a period of 3 years from the date of commencement. The agreement shall stand concluded on 31st May 2025 if lacks of time. Now, my lord.
31/5/25, right? Okay, you got 2 more years to go.
Now, here what happened, my lord, one thing I should clarify. In this agreement, it has been referred because original agreement, the weighbridge, first settlement was made in 2017. Now, in 2018, what happened, your lordship? They made it into a integrated check gate cum weighbridge. Now, integrated check gate cum weighbridge means what, your lordships? Means, my lord, within the premises, my lord, the checkpoints of the government for the collection of royalty and all, for the convenience of the truckers, my lord, this has been shifted and brought within the premises of the weighbridge. That is the only difference. So, my lord, this is categorically this, my lord, and the amount, my lord, your next, your lordship, that is 25 lakhs, payable in 3 equal installments, my lord, 8,33,350. Now, my lord, I have been paying the dues, my lord, promptly, regularly, without any fail.
So, you're coming before the court for breach of contract?
No, I'm just coming, your lordships. Now, my lord, lordship, if I can take my lords, this is one. Ultimately, my lord, when I was paying my dues, lordship will kindly come to page 76, annexure 13. Letter dated 14th July 2023, my lord. This is addressed to me. You have informed that the agreement for operation of weighbridge and I'm sorry, extended up to 39/2023, my lord. That was a root shock for me, my lord. As conveyed by the government in letter number, date and date. I don't know, my lord, this is their internal thing. This is in 23. Agreement was executed in 1st June 2022 for 3 years. I have been paying, and my lord, since it was for 3 years, I had to carry out the repairing. I had to, my lord, put the infrastructure in right place, playing, my lord.
What happened
now, my lord, thereafter, my lord, I approached them, your lordships. I said, my lord, this is absolutely incorrect, my lord. This might be due to oversight. So I was under the impression, my lord, that this stands corrected, though there is no formal communication as such. So next what I did, my lord, there were 3 installment dues. 3 installments were due, your lordship, for 23-24. So, my lord, if your lordship come to page 77, your lordship.
Yes.
I have made the payment, my lord. I have submitted the challan, my lord, for endorsement to the Commissioner of Transports. That is, my lord, first, second and third challan for installment for 23-24. Now, my lord, I was under the impression, my lord, this will be done. Now, my lord, to my shock, what happened? I received the letter, impugned letter dated, my lord, at page 81. Annexure 15. 1st August 23, your lordship. Return of challan and challan for second and third installment of the annual fees 23. With reference to the subject cited above, I am to return here with the original copy of challan 22nd and third installment of the annual fees for the year such and such, as the government has conveyed its approval for extension of agreement only up to 39/2023. This is just shocking to me, how it could have been done. Now, my lord, this is my grievance, my lord. Now, before, my lord, I conclude, my lord, the position of law on this thing, my lord. These kind of agreement, my lord, the source of power, my lord, Article 298. Now, 298, my lord, give liberty to the state government, my lord. State government through its department, you say in the name of the governor. But, my lord, the department can enter into commercial transaction with a citizen, your lordships. Now, my lord, first thing, my lord, I took the pain to take your lordship to the statutes, just to show that these agreements are not normal agreements. These are statutory agreements. They are actually, my lord, seeking to enforce, my lord, all those requirements laid down in the statutes. Now, my lord, in normal course, what happened, your lordship? We come with a contract. Obvious question comes, my lord. This is in the realm of private law, contract. Go and seek an enforcement in the civil court. That come. Though there are exceptional situations, my lord, few situations arbitrary and all court has carved out, your lordship, where still the court can exercise. But when it comes to, my lord, statutory contract, my lord, lordship power is very, very wide. If they are making a breach, this kind, your lordship, definitely lordship has the power, my lord. I'll just, my lord, not trouble your lordship with too many. I think this decision, the leading judgment start with, my lord, that airport authority. And thereafter, so many decisions there, my lord. I'm just relying with reference to 298. 1990, my lord. 3 SSC 752. Paragraphs 12 and 18.
19, paragraph?
My lord, this is 1993 SSC, page 752.
Yes.
Relevant paragraph is paragraph 12 and 18.
Yes, Mahabir.
Lordship. If I can read my little long, my Lord, but then I think this will clarify the thing. It is well settled that every action of the state or instrumentality of the state in exercise of the executive power must be informed by reason. In appropriate case, action uninformed by reason may be questioned in arbitrary proceeding, as arbitrary in proceeding under 236 of the Article 32 of the Constitution. Reliance in this connection may be placed on the observation of this court made in Radhakrishnan Agarwal's, and it appears to us outset that in the facts and circumstances of the case, respondent company ISC, an organ of the government or an instrumentality of the state, as contemplated under 13 of the Constitution, the State Act in its executive power under Article 298 of the Constitution in entering into in contract with individual parties. Article 14 of the Constitution would be applicable to those exercise of power. Therefore, the action of the state under Article 19 can be checked. See such and such, page such and. But Article 14 of the Constitution cannot and has not been constituted as a charter of judicial review of the state after the contract has been entered into, to call upon the state to account for its action in its manifold activities by stating reason of such action. In a situation of this nature, certain activities of the respondent company, which constituted the state under Article 12 of the Constitution, may be in certain circumstances subject to Article 14 of the Constitution in entering or not entering into the context, must be reasonable and taken only upon lawful and relevant consideration. It depends upon the facts and circumstances of particular situation whether hearing is necessary and reason have to be stated. In any case, right conferred on the citizen which is sought to be inferior, such as action is subject to 14 of the Constitution and must be reasonable and can be taken away only upon lawful and relevant. So this is basically doing it. My Lord, when state is entering under 298, 14 matters, you just cannot violate it. And this is a statutory agreement, your lordships, as I have pointed out, my Lord. Now it is admittedly, my Lord, till 220 to 25, my Lord. Suddenly they have issued a letter saying no, it's up to 23. So, my Lord, that is gross.
Facts and terms of every case. Lordship, it's not a formula that can be applied across the board. Yes.
My Lord, here is the case, your lordship. My Lord, is it not shocking? An agreement made due to expire in 25. Now, what will be the condition of a, my Lord, lessee? What do you do?
Courts is more disturbed with the manner in which it was renewed. That is because courts very disturbed with the manner of renewed.
No,
the order of this court does not say anything about that that coming to this court and filing a partial renewal will ensure renewal. It does not say that. That's
lordship,
that is why, you know, if it is in other circumstances, yes, but the renewal is not a fresh contract, it's a renewal, and they come here saying that okay, we'll examine and say to comply.
Well, that is their order. That is not my look. That is their order. Look out, your lordship. It is their order. Now, my Lord, the other thing, they have made similar contracts, my Lord, with UCM, my Lord, one place. I have made a categorical, my Lord. 2 or 3 modes are there, your lordship.
No negative equality.
No.
Go on the facts of your own case.
It's not the question of negative equality, your lordship. What I am saying, my Lord, there they have made the settlement similarly situated. They have not disturbed.
So you're alleging malice?
It's not the question of management. You have made a renewal for 3 years. Because lordship will see, my Lord. Forget about, my Lord, what
right now it's plainly put as a breach of contract.
No, my Lord.
So you can't seek specific performance from this court.
My Lord, this is 298, your lordship. Now 298
It doesn't matter. It can be study contract, so it doesn't matter. 298. It's not a question of are you saying that it's a state monopoly? That's why study contract, like referring to motorways, and it is a monopoly of the state with regard to enter into these kind of contracts, right? As per the rules.
No, my Lord. What I am saying, my Lord, the other day I have done a case. Forget about your lordship. Even lordship do not want to take it as a statutory contract. Lordship is not inclined to enforce the statutory rights. Assuming for a second, what happens in other cases, starting from Tata Cellular, what they say even in a contract in the realm of private law, what are the jurisdiction of the court? He said, if it is unreasonable, if it is arbitrary, is it not unreasonable, my Lord? It has been made for 3 years. I have made the investment. Now suddenly you come up and say, no, they have not rescinded the agreement. This is so wrong.
I'll reply, my Lord.
And my Lord,
I'll reply, my Lord. The Lordship kindly see, the manner of collusion is obvious. Your Lordship has taken note of that fact. My Lord, kindly see the rule which my friend has pointed out at page 25. How this rule is being breached by our officer, my Lord. That is the very sad part of affair, my Lord. Rule 3, my Lord.
Yes.
the government may install and maintain by itself as many weighbridges for the purpose of section 144 of the Act on such places as it may think necessary, or may allow any private person or body of persons, company, organized to install and maintain such weighbridges on payment of lease amount to be determined in each case by the government after calling the tender. So tender is one of the requirement, my lord. I put a question, my lord. When the lease was renewed on 2022, whether tender was floated? No tender was floated. I'll deal with the renewal part also, my lord. Renewal. Provided that no lease shall be granted any private person, body of persons or organization unless fulfilling the criteria. Now, when the tender was invited in 2017, my lord, the lordship has seen the term. It was for a period of 3 years, my lord. And therefore, your lordship kindly see what the tender is requirement of the statutory rules. My friend has said it is a statutory rule and tender has to be there.
Yes.
Now kindly see the rule, my lord, which my friend has the lease agreement at page 34, my lord, page 34, and the term relevant page is at 36, my lord. This, your lordship may kindly keep in mind the date, my lord. This is the date of 7th December 2017 to 7th December 2020, my lord. This lease is for 3 years after tender, my lord. And the amount, your lordship will also take note of that it is 25 lakh rupees, 17 to 20, my lord. Now kindly see 36 in that light. The license shall remain valid for a period of 3 years, which in accordance with provision of Rule 7 of Meghalaya so and so and 2000, but will be subject to revalidation on yearly basis. So this license is for revalidation for yearly basis as the full payment of annual so and so and expiry. So lease was for, my lord, for period of 3 years. This lease expired on 7th December 2020, my lord. Now my friend says that it should have been renewed in terms of Rule 7, my lord. The requirement of rule is that I have to call for tender, my lord. Kindly see now in that light, my lord, what my friend is reading is that now extension is being sought, my lord. Kindly see page 44. This extension is being sought, my lord. And then, my lord, the affidavit is filed. In affidavit, they refer to this and then all of them approach this Honorable Court. The Honorable Court has not made any observation. Page, if your lordship's order is there, my lord, page 50.
Yes.
Then the still running the weighbridges in view of the affidavit's place, so and so accordingly petitioner approach the state respondent. So if I take it, my lord, they would have been entitled for yearly extension only, and then therefore I am entitled to have the tender, my lord, as per Rule 3, my lord. Tender is must, as being a statutory contract, tender has to be there. Now kindly see the agreement which has been entered by the department and I say it is in violation of tender, it is violation of your lordship's order, and it doesn't confer any right by simply entering into the agreement, my lord, and that is of page 53 is the, because page, my lord, page 55. Now this agreement is of 1st June 2022, my lord. So 1st June agreement is a fresh agreement without tender, my lord.
Yes.
This is, and Rule 3 of statutory rules clearly says that it has to be by tender. Therefore, there is no illegality or impropriety by the government in saying that we will not be extending the lease beyond 30th September, my lord. And your lordship kindly mark this aspect also, that this 25 lakh which was the bid amount of 2017, it has remained static for this extended period. 3 years is over from 17 to 20, 20 to 22 they got extension, and now 20 to 25, my lord. So therefore government is well within its right under the statute, my lord, to cancel it and not to extend it.
It's never cancelled.
And not to extend it. whatever manner this has to be read, it can be read, my lord. This issue, my friend has placed one Supreme Court order in the writ petition, my lord. Kindly see the apex court order. And I have been, I must confess, my lord, I have been beneficiary of these way bridges cases, my lord. So therefore, your lordship will see this 2012 writ SLP which I filed at page, as a private lawyer, I was beneficiary. Page 32, if your lordship will see at the of the writ.
32.
32, my lord.
Yes.
This is the SLP order of SLP dismissing the order judgment and dismissing SLP against the judgment and order passed by division bench, my lord, of the Guwahati High Court, and that judgment I will place, my lord. In that judgment, my lord, this 2009 rule was in question. I will just show, my lord. I was there, therefore I knew. However, we direct that if your lordship will see, we do not find any reason to interfere with the impugned judgment. First page at page 32, my lord.
Yes.
So the impugned judgment, my lord, if I can place this impugned judgment, what was the impugned judgment, my lord? Which? This is the judgment, my lord, is of 2012 1 Guwahati Law Report. And this judgment, my lord, deals with 2009 rules only and Rule 6 and everything, my lord. Straight away I will take your lordship to paragraph 26 at page 15. And 26 and 27, my lord.
26.
At page 15, my lord.
Yes.
What is, however, of paramount importance to note that unless permission was granted under the executive instruction aforementioned or is granted under 2009 rules, the question of way bridges being installed or operated by party does not arise at all. Granting of permission under 2009 rules 2 is therefore sine qua non for installation and operation of way bridge, and consequently a lease cannot be granted unless permission is granted, or lease cannot be renewed unless the permission itself is renewed. We may pause here to point out that a close reading of the agreement in question shows that it was a lease in perpetuity, inasmuch the agreement provided for renewal of lease on making of an application, fulfilling the terms and conditions of the agreement and payment of renewal fee. Same argument. After coming into force of 2009 rules, this right to have renewal of the lease becomes subject to paramount condition of renewal permission under Rule 2009. In other words, as already indicated, unless permission as regard the installation and operation is renewed, the question of renewal as the present one does not arise. So rule has to be followed, my lord. That is the requirement. And then paragraph 44, my lord, at page 99. It is paragraph 44, my lord. It is of immense importance to note that it is indeed legally permissible for the state government, even under Rule 2009 rules, not to renew permission for installation or operation of way bridge if the decision as regard non-renewal of permission is in public interest. So, my lord, the lease was for...
So his case are different footing. It's not a question of non-grant renewal. His case is that renewal is granted,
renewal is
being taken away.
Renewal is granted contrary to 2000.
Now questions whether decision is like, it's only question reasonableness.
Yes, no, I'll answer, my lord. I'll answer straight away.
After by your own action you've renewed the...
Yes, my lord. My action...
Whatever, right or wrong, you've renewed it.
Yes,
right?
my lord.
Yes.
The question
now
which
the action of your non-renewal,
if I frame
non-acceptance of the...
if I frame it slightly differently, my lord, the question which I frame it, my lord, the requirement in rule is that it has to be, the lease has to be given, or the license has to be given on tender. Admittedly, 2020 is not the contract which is based on tender.
But then,
and the renewal, if I take the other way also, my lord, the question of renewal, my lord, his lease could have been renewed from 2020 to 23 only, because he is entitled to renewal for 3 years. If he pays fees, etc., and the terms, that is also, my lord, is going to be over. And there is no renewal. There is no renewal, and in public interest, my lord, your lordship has noted 25 lakh was paid in 2017. 2022 agreement is a contract which can, whether it can override the statutory requirement, my lord. Statutory requirement is tender. If there is so therefore the contract has to give way
No, because renewal, as the clause 7 says, renewal.
If I take your lordship,
and no such permission shall be granted renewal.
Renewal is, my lord, on the expiry of the first term.
Contract, yes.
So there is no renewal in the case.
Shall be granted renewal unless the proposal of renewal, as a case is coming with certificate. That year-to-year thing is missing. It's then agreement, but it's not in the rule.
The agreement, because, my lord, the rule says that renewal will take place on 2022 only. 2022 there is no renewal because there is no contract which is in existence. Renewal in terms of 22, one renewal, my lord. It is not in perpetuity. I have shown the Guwahati High Court judgment where, my lord, it says that in the public interest 25 lakh rupees if the department, by misreading your lordship's order, favors the party, my lord. I have got the CAG report also, which says that favors a party, my lord. Whether your lordship would exercise this equity.
Anyway, I didn't realize it's still 30th September. You file a short affidavit.
Yeah, I'll do that.
Actually, I thought of disposing of now only.
I'll place it.
No, my lord, one thing I don't know, my lord. Wherefore my learned friend is talking about tender. 7 is very clear and categorical. When the fast settlement is made, the tender is required. My lord, renewal, where is the question of, my lord, and lordship will see lordship's own judgment. Lordship has referred to the statement. Now, actually, what he is saying, the statement made in the earlier petition by the government is wrong. Now, can you question?
Counsel, the petitioner issue notice stuff. Maybe some issues come up for this. Otherwise, I was going to dispose of issue notice returnable in all. It's not returnable. Issue notice. Who's assisting you?
Mr. Sincon.
Mr. N. Sincon, accept notice in behalf of the respondents, being led by the then Advocate General. So no further notice called for. State to file affidavit within 1 week. 1 week is now is the 4th.
There is a vacation, my lord, because there is some holiday in between. So 10 days your lordship.
My lord, my only concern, your lordship, the two things, your lordships. They may disrupt me, my lord. They are saying, my lord, it's
no question. No. See, he's going to 39.
The other thing I need to other thing I need to point out, your lordship.
Yes.
Second and third installment. Now they are not accepting. Now tomorrow they say you have become a defaulter.
Doesn't matter. We will that nothing that cannot be undone.
Obliged.
But Mr. Sen is a difficult case for you.
My lord, I'll say this. Lordship will see one thing. I am standing for Nehu. Today I come and make a submission. Tomorrow I say Nehu has done a wrong. Nehu's officer. This kind of thing should not be given indulgence. And there is Advocate General coming. Advocate General is coming and making this kind of
I can't cover the action
very
of wrongdoings of officer.
Well,
government and officer. There is a distinction between government and officer.
Statement made that it will be renewed.
Yes.
You should not make this kind of casual statements.
Yes.
Anyway, I'll try to satisfy your lordship.
My lord, this matter relates to election of the Sardar in Raichapong. Now, the electoral list was prepared by the election committee under the rules, and they have notified it, electoral roll.
Okay.
My lord. And they fixed the date for election. And before the election is held, the district council has issued impugned order. Lordship, can you see the page number 40 now, my petition? The short issue involved, my lord. Page number 14.
Yes.
This was issued on 8 August, notifying the 4 candidates. And serial number 4 is the writ petitioner.
Okay.
And thereafter, my lord, they have issued, the election committee has issued the notice, page number 20.
Raichapong.
Raichapong. Lordship is quite aware. Page number 20.
Very contentious. Anyway. Yes.
Page number 20, Lordship, can they have a look?
20,
my lord.
Okay.
This order was issued on 25th. Notification.
20.
May I read with Lordship permission?
Yes.
It is notified that the election of Sardar within the Raichapong and such will be, which is scheduled to be held on 26/8, is hereby postponed after receiving instruction from the office of the executive committee and such.
The day before election?
Yes, they fixed for election on 26. But now they say that the instruction received from district council. Now, my lord, the instruction which is available is page number 22. Page number 22. The same date, 25th August, and it says it was issued by district council. As per the subject cited above, I am to direct you to inform you that the executive committee council, after careful perusal of the complaint pertaining to elections of Sardar, Raichapong, and such, it has been decided that said election is suspended until further orders. They said there is a complaint. We don't know who is the complainant. And thereafter, the next page, page number 24. 24. It was passed on 28. My Lord, may I read, my Lord? As per the subject cited above, I am directed to inform you that the Executive Committee, KGTC, after careful perusal of the complaint, a special consideration has been taken thereby directing you to include the names of persons whose names have not been included in the voters list, and the same shall forward to the headmen of the villages within the right chapel on or before 8, that is today, along with their epic for purpose of verification. The headman shall forward the additional list to the election committee on 5th September along with both the hard and soft copy. In the meantime, the election committee shall publish the additional voter list and other requirements within 7th September, and the election of the Sardar Rai Sapong shall be held on 9th September 2023. Now, electoral list has been prepared, page number 26 onward.
You have objection to this list?
My Lord, no one raised objection regarding the voter list.
No, this is the old electoral list.
2023, this.
Now, what about its new name? Do you have objections on the names there?
My Lord,
how many names have been included in the new voters list?
My Lord, more than 1,000 electoral lists are there, names are there, and
have been newly included.
My Lord, in the list, in the new list.
And in the old list, there were 495 voters. As per your submission, what does it say?
My Lord, page number 26 onward, Lordship, can you see? This is a new list.
495 votes.
My Lord. So this was this was prepared by the election committee.
The total voters, how many are there in Ratchabong?
My Lord, it is a combined.
No, many. It'd be more than.
More than.
How many altogether?
Page number 39. More than 1,000.
Yes.
More than 1,000. Now regarding this voter list,
how many names have been introduced into the voters list now?
My Lord, total is more than 1,000.
Newly introduced?
No, it is combined together, my Lord.
No. What are the names that have gone for reintroduction? Now the elections was postponed because there are some voters whose names don't appear in the voters list, and so the council said, okay, fine. We introduce the names, send the epics, and send that to the respective headman verification, and they brought to vote. Correct? Now, who are those voters that you have? Do you have any?
My Lord, we don't know.
Objections to them being
no one raised objection. And may I just cite the act?
No, not raise objection to this original electoral roll.
No one raised
about
objection.
the new names. You have no idea of the new names.
My Lord, no new names. My Lord, I'm not aware. I'm the candidates, my Lord.
And the candidates?
I'm the candidates.
No, of course you're the candidate, right?
My Lord, the election list is prepared by the election committee separately from the village.
No. One thing is that now when this new voters list has been now 4th, 5th, till 5th tomorrow, correct?
Yes.
After verification, are you going to hang up that voters list that these are new voters or not?
My Lord,
I think it's already displayed.
No, the 5th is the last date, that's tomorrow. Right. But then will they have a possibility to object to the voters list, inclusion of people maybe one not from Ratchabong?
Originally, the election was scheduled to be on 26.
Right.
On the basis of various complaints, then we had to stall. And we have made a decision that those names who are reflected in the epic, they should be given the opportunity.
From Ratchabong?
From Ratchabong.
Do you have any other conditions regarding maybe he might be a voter for the legislative assembly election, but whether he can be a voter for Sardar Ratchabong? Are there different criteria or same?
Last time there was an issue, I think this court was sitting in division bench. The same issue has arisen, where a non-tribal deciding from outside, marrying a woman from that village, and as per the law, he becomes a voter. Now that issue has not been resolved. We're supposed to bring a new law. I think it could not be done or something went wrong because of change in dispensation.
Who's now this acting Sardar?
In fact, Your Lordship, I have to apologize. The office took time in transmitting the records. So whatever I'm submitting is just on the basis of what I've been informed.
Because see, if they should have a opportunity to object, that's the only thing. If the voters list was brought out since this first electoral roll was brought out when
This matter
can come tomorrow.
It'll come tomorrow, but then yes, maybe we'll need some order because we cannot have a fraud election. Yes.
Right. And the Act 1997 Act, Lordship, District Council, Lordship, just allow me to
tomorrow I can police it tomorrow. Yes.
Some order may be passed. Otherwise, they will say that list is not prepared, so they may proceed with a new list. That will affect the candidates.
Matter is coming tomorrow.
No, come tomorrow.
I'll come with
Just have
instructions.
Stop. The matter is of some urgency as much as the elections to the office of Sardar Rajawan by the impugned letter dated 25th August, by impugned order dated 28th August 2023 has been rescheduled to be held on the 8th of September, with additional voters being included in the voters list. Stop. In review of the matter, list tomorrow, learned special counsel for you to come up with specific instructions. Stop.
Much obliged.
Item number 5.
Please, Lordship. Lordship, if complied with your Lordship's order.
You've got the expiration amount?
Lordship, we've received the check. It's been deposited. Hopefully, it will not be dishonored.
Yes, as personal order of this court, the concerned officer name
Albert Anthony Dakar.
GA Dakar is present in court and submits that the ex gratia payment has since been released. So accordingly, his presence is discharged. This is matter for the orders on?
Because they yet to file an affidavit.
After 3 weeks.
Right.
Yeah.
Published.
Affidavit will file in the meanwhile.
Published.
Item number 6.
Please, Your Lordships. Item 6 and 7 are those matters where we are challenging the STR issued by the cantonment authorities. Can you have the last order, my lords?
So what's happened now?
So what we're informed, my lords, is that the committee had called the stakeholders for their suggestions. Suggestions have been taken, they've been incorporated in some sort of a report which has been submitted with the central government. The central government is awaiting for reports from similarly constituted committees all over India, and they'll take a call on this. That will take a little bit of time.
How many cantonments are there all over India?
I'm 52.
52, Your Lordship, if I'm not mistaken.
As far as the exercise of Shillong is concerned, we understand it's over.
So they'll all fall in civil areas now?
Well, if the final order does come.
If all civil areas, what will be the status?
The STR rules.
Normal or
it will become a normal levy as far as we understand, because there are two suggestions. One, that the Land Transfer Act will not apply.
As per para 20, cantonment area. But will it be classified as cantonment area, but maybe pre?
So there is some issue with that, because they're saying that certain areas which are in the civil areas are certain vacant areas which are owned by the cantonment. Even post excision, that will be retained by the central government. That will not go. The management will not be transferred to the state government. So only those areas which are under occupation, civil areas which are under occupation by way of a lease or an old grant.
That means that the Ministry of Defence, they'll divest themselves totally of any leases.
Only the management, correct. As far as the leases are concerned,
the leases will go.
Lordship, which will be transferred to the state government.
State government under revenue.
Lordship, so the Revenue Act will apply. The revenue regulation will apply. So as far as our challenge managers are aware, this is the question of the fixation of the rents under the STR policy. So that policy will be scrapped off. And
then
the rent revenue
regulation will have no meaning after that.
Lordship, which is why it's just taking a little bit of time.
Mr. S. and then the Council Parish submits that the process for the exclusion of accession EXCISI of several areas from the limits of Shillong Cantonment Board is still under progress. He praised the matter. The same is not disputed by Mr. Emlingdor appearing for the respondents.
And for Your Lordship.
And let the matter appear after 4 weeks.
Obliged.
Item number 8.
May I please, Lordship? I filed an application for adjournment of this hearing.
So hearing 711 application today?
Yeah, the hearing, my lord.
Why is it adjournment? You pay some cost.
Council is indisposed, Lordship.
I donate to the bar.
Yes?
I will donate to the bar. Pay some cost.
Lordship, actually the conducting council is indisposed, Lordship.
Who's the conducting council?
SI. Soria, Lordship. SI. Soria.
Oh, he's indisposed. Yes. That's the other thing. Anyway, we'll let them go this time. An application of adjournment has been filed on behalf of the council respondent to be indisposed of. When do you want it?
Can it be, my lord, on 12?
12 Lord.
Yes, sir. Yes. At the request of the parties, list this matter on 12, please.
Obliged.
9.
Yes, now you clear the matter.
His Lordship, what happened? This test case number 8 of 2013, the dismiss case appeal number 2 of 2019 is arose from the TS number 8 of 2013. So because this is the same matter, is a land dispute matter, same matter. So how can they? Because
So you want the
miss case?
stayed?
How can the?
Meanwhile, let it be stayed. Let the misappeal be disposed of.
Lordship.
My lord, the position, if my lord kindly come to the order of this honorable court, is very clear, my lord. What was supposed to be transferred, we have transferred it, my lord.
Now it's fine, but the thing is that let the title suit be stayed in the meanwhile.
Yes,
let the
Lordship.
misappeal be disposed of.
Lordship.
So it will lead to multiplicity of proceedings.
But
because same matter
is proceeding in the trial court, the misappeal is in the another court.
Yes, the same matter, same subject matter. Only the miss case. How can the miss case can be taken up by some other? There will be a conflict.
No, it's not that can be taken under. The miss case is on a different footing, doesn't matter. But the thing is that title suit, there was no order for transfer of title suit to the other court.
let him file a petition before this honorable court to
Yes,
transfer the title suit.
Also file the application. Yes.
Let him file. Even if my lord,
Mr. P.T. Sangma prays him allowed to obtain instructions to seek transfer of the title suit number 8 of 2013 to the court trying the misappeal.
Lordship.
Just after 1 week.
Lordship. After 2 weeks, Lordship.
2 weeks.
Much please, Lordship.
Item number 10.
My lord, what happened is
fresh matter.
along with my sister, had filed a title suit.
The fresh matter?
Jurisdiction matter, yes.
Fresh matter?
Yes, my lord.
There's a delay?
Delay, 3 days delay, my lord.
Yes.
It so happened that I filed one title suit along with a miss case under Order 39, Rule 1 and 2. And under Order 39, Rule 1 and 2, a status quo order was given. Thereafter, one respondent filed a petition under Section 21, CPC, challenging the jurisdiction. Thereafter, the learned court below passed the impugned order, just a short, cryptic and confusing kind of order, thereby completed, means altogether finished the entire case. The order goes like this, my lord.
Yes.
CR put up today. That is the final order. Matter is fixed today for order on miss case number 1, 2021. That was the miss case on the application file under Section 21 CPC. Out of the instant main suit, title suit number 3, 2020. That was the title suit. Miss case number 1, 2020 is allowed and disposed of.
Sorry, this is an appealable order. Why you've come here?
My lord, look at the miss case which has been.
Why you've come here?
That the order has not clarified many things.
5, how will it lie?
Pardon?
See, you have a form of appeal. This is from the regular judiciary, correct? Then,
my lord,
the judge is there.
The court below has acted without jurisdiction, and the jurisdiction has not been exercised correctly.
Doesn't matter. That's a wrong. If according to you is a wrong order, you can appeal.
Appeal does not lie from the order, my lord. I have seen.
Why?
This is not an order where appeal is specified in the.
See, it's a return of plaint. Yes.
Because the order has become so confusing because of the jurisdictional problem. Had exercised jurisdiction not vested in it. For example, the petition number 1, if she has no jurisdiction to try the title suit, how can she try pass an order on that petition? She has no jurisdiction.
You don't come to 227.
Yes.
You don't come to 227. You come to 115. So 115. Then what are the limits?
But
then.
Yes.
Then.
Fail to exercise jurisdiction so vested. All three, A, B, C, 115, 1, A, B, C, all three are involved, my lord. Now this court has got no power to transfer a case from.
Why have you come to 115? If you feel that there's been total lack of jurisdiction, total not adherence to the
this order cannot be considered a
why
decree,
you come
my
to
lord.
115? Then why did you come to 227?
It cannot be considered a decree, my lord. It cannot go on.
Why have you come to 115? Then?
Because the court has exercised
revision
jurisdiction not vested.
Revision orders. This is a final order.
All the criteria given in 1151 A, B, C are fulfilled.
Is it a final order or not? Is it the final order or not?
But the order
is it the final order or not? Please answer the court.
Not really final.
Then you said the case plain return to the plaintiff. That's order number 711. 7 years.
Thereafter the order says case is returned to the plaintiff to be present before the district council court. So this court has transferred the case from the district courts to the district council court without any jurisdiction.
They have returned the plaintiff, you return in a court which has jurisdiction. That's all.
No, before that, why return to me when the miscase has been allowed?
2020 is challenging the jurisdiction of the court.
The miscase has been allowed. The prayer in the miscase is on page 25. It says reject and dismiss the title suit. So title suit has been dismissed.
Dismissed, yes.
Now what is there to be taken to the district council court?
Maybe the application is wrong, right? It says not for dismissal, for presentation the court of competent jurisdiction.
This application has been allowed by the order.
You go and present your. There's nothing wrong. You go and present your suit in the proper court. That's all. This could be two tribals arising suit lands between joy.
I need the guidance, my lord, how to go to the district council court.
This court give you guidance.
No, what about my court fees I paid here and the ad valorem fee, etc.?
That is all.
We'll adjust. Nothing about that in the.
You will draw it, otherwise we'll dismiss it. The petitioner before this court in a petition by under section 15.
I will draw and go there.
Assailing an order rejecting the plain for presentation. Okay, Mr. P.K. Bora. After hearing some Mr. Bora, please allow to withdraw the instant civil revision application with permission to allow him to approach the appropriate forum. Yes.
Yes.
11.
First, the delay of 3 days, Miss case also, condition application, Miss case number 13, 2023, in CRP number so and so. The delay of 3 days is made out in the applications condoned. Registry to diarize and register the accompanying civil application, and the main civil application. After hearing some time, Mr. Bora, please allowed to withdraw the instant application for presentation in the court of competent jurisdiction. Okay. There's nothing is there. The applications for challenge jurisdiction. Yes.
Respondent number 3, the examined final affidavits.
Well, it is a contempt matter. The respondent number 2 and 4 has filed the affidavit. According to me, they are yet to comply the order.
How much more such an inquiry can we do? You said they've removed the name from there.
They have deleted the name in the run court law.
It is not only deletion, but the Lordship has directed the respondent to ensure that the social benefit should be extended to the petitioner.
So you.
Lordship, I see the operative portion, otherwise the litigants are helpless.
You do one thing, Mr. Kharmi,
The direction in the order is to allow them to work and to disregard the earlier
job. There is a problem.
Then you file a refreshed writ.
Lordship, can you see the Lordship direction? Page number 17 of the petition, the contempt petition.
17.
17, para 8.
Yes.
But may I just read out? In this view of the matter, looking into the facts and circumstances of the case, and as per the submissions of the learned counsel for the respondent number 5, it is directed that the respondent number 3, that is the PTO, shall ensure that the petitioners be allowed to avail the benefit of the scheme under the census and such. The respondent number 5, this is the headman, shall also allow the petitioner to work, and they are to disregard the earlier job cards, ration cards issued by the Northern village. It is further.
Where he made statements not allowed to work? In the contempt.
In the contempt petition we have
specific statement.
Madam.
That is not allowed to work. Where is that?
Lordship, can you see para 2 onwards? Para 2 is a submission to the man.
Take down and dispose it of. It is stated that the bar and affidavit has been filed by the filed by the respondents 1925. You're a Sardar, you're not allowed to work.
It's not
It's
correct.
not allowed.
That is not correct. You file an affidavit.
No.
Yes.
Affidavit
affidavit has been filed on behalf of the respondents number 2 and respondent number 4 who are alleged to be in contempt. The order dated.
Order dated.
Order dated.
My Lord, 8/7/2022.
8/7/2022. 2022. Stop by the said affidavits. Firstly, the state through the video, either block the development officer motion road CRT block has a paragraph where they remove the name.
But Lordship referring to my contempt application.
No, I'm referring to the affidavit.
Filed by us.
Oh, my affidavit.
Yes, when para 10, it has been recorded as follows. Take down para 10 at page 5. Done. So further, next affidavit of the respondent number 4, who is the Sardar of Wali village Darbar.
Para 5.
Has at para 5. Para 5 stated that para 5 and 8 that the petitioners have not approached the said respondent or submitted a letter of intimation to show the willingness to work with the village under the MNGRES scheme. Next one, review the matter as the order has been substantially complied with. No further. There's no further issue remains in the instant contempt application. And the same is ordering close. Go and file, go and show your willingness. The villages always happens like this. They get one order, they try to show their ego. That's the only thing. Yes. Yes.
My Lord.
You filed the agenda?
No, my Lord.
Why?
My Lord.
In interim order, we will vacate.
My Lord, will last answer be given. We'll file through it.
Yes, Mr. Arja, please follow up further. 1 week's time.
My Lord, 2 weeks.
2 weeks time to file affidavit. Yes, stop this also. Interim order should continue to the next date. Is a transfer matter?
My Lord.
Enjoy yourself. Yes.
This is your Lordship. Lordship, in item 13, 17, 20 and 21, your Lordship, we will need some more time, your Lordship, to file the affidavit. Item 13 to 23, your Lordship, these are analogous matter.
13 23.
Lordship, 13 to
you file affidavits in other matters?
No, Lordship, I have been interested with item number 13, 17, 21 and 20, your Lordship. So in these four...
17, 21 and
20 and 21, your Lordship.
13, 17, 20, 21.
Lordship, yes.
And then?
Lordship. So I need some more time, your Lordship.
What about the other respondents, the other councils?
If Lordship is please.
Any objection?
No, your Lordship.
2 weeks time, Your Lordship will.
Yes, as prayed for 2 weeks time granted to state respond to file affidavit all the connected matters.
Apply, Your Lordship.
Incident matter and all connected matters.
This is from item 13 to 24.
Very good. Yes.
Apply, Your Lordship.
24.
May it please your lordship,
Yes.
actually in this matter your lordship, I've just been informed this morning that we would be receiving the affidavit, so I'm praying for just a week's time.
Yes,
Fine.
Ms. Aswam House Vice also prays funds allowed for the 1 week's time to file. Yeah, what about you? Not required. Not required for affidavit. Yes, sir. It is submitted by so and so that no affidavit will be forthcoming respond number 4. Just after 2 weeks. Just after 2 weeks. Yes.
25.
Another series of cases. Yes.
Respondent are yet to file affidavit, Your Lordship.
Please, your lordship. Your lordship, I'm praying for only 2 days time, your lordship, to file my affidavit on behalf of the state
It's
respondent.
20, 24 and 25. So 25 only.
25, your lordship.
Yes, MS also prays funds allowed 1 week for a time to file affidavit just thereafter and so on.
Your Lordship, the affidavit, the service report upon respondent for, Your Lordship, I filed during the course of the day, Your Lordship.
For?
Respondent for service report, Your Lordship.
You're going to file?
During the course of the day, Your Lordship.
Yes, Mr. G. also submits that service affidavit on behalf or with regard to service on respondent full to file the course of the day. Yes.
Obliged, lordship.
Yes.
Yeah, please, Lordship. This matter, Your Lordship, this government has filed an affidavit. However, Your Lordship, this respondent number 4 and 5, they are not appearing. They have received the service to that effect. Order also has been passed, Your Lordship.
Yes, you already filed service affidavit. So
yes, Lordship. Now, my submission, Your Lordship, this they have enclosed this order, Your Lordship, which I like to bring before this court, Your Lordship. They say that government is saying that there was a direction from the this order dated in their affidavit, my lord. Page 9, Annexure 1. They stated that whereas in white letter number so and so, it was directed that the managing committee of the Wrong Security Deposit LP School be instructed to re-advertise the vacant post and re-interview for the smooth functioning of the school and to avoid the court cases in future. However, there is no information on the following follow-up of the direction communicated to this end. Lordship, this is the actually there's one document. This issue has been already resolved, Your Lordship, because they said they did not mention the reason why they cannot approve. They have not mentioned anything regarding the mark sheet. Your Lordship, there is another order whereby the sub-divisional school education officer issue on 28 June. This is on 28 June, where it says that forwarding the score sheet of interview Rongri LPC school, upper primary school for your current base. Now, Your Lordship, this is it. As per this, what I got instruction is as per this order, all the member has signed, Your Lordship. All the member of the panel member have signed. And interestingly, what I got instruction, even the petitioner has filed the ATA. They said that this respondent number 4 and 5, their husband and wife. Respondent number 4 is the headmaster come secretary. 5 is the person who filed a complaint, and he is the wife of the headmaster. And they have hired one NGO, based NGO by name Grenade Sangma, to file a complaint against the petitioner. And that was there on 28 June 2018. There was an agreement. There was a meeting between the headmaster and the SD sub-superintendent.
So headmaster cum secretary,
yes,
is the husband of number 4.
Husband number 4. So the wife filed a complaint, and that complaint has been resolved. There is On 28 in my writ petition.
See, then you file additional affidavit then.
Lordship, I filed. Lordship.
After it's been filed on behalf of the respondents number 2, stop Mr. P.T. Sarma submits that certain additional facts have come to light. He seeks leave the court to file an affidavit. Prayer is allowed.
Lordship. 2
weeks time granted for affidavit file. We'll see if whatever you say is some truth, they will look through it.
Lordship.
7.
Obliged, Lordship.
Those are the petitioner.
My Lord, Mr. D.K. Datta, my Lord, as per the
Yes.
list. My Lord, here we are yet to file our affidavit. My Lord,
Yes.
may give us 1 week time, my Lord, the affidavit will be on board, my Lord.
Mr. Arconi pays for, none appears for the petitioner. Stop next, Mr. Arconi, MS Arconi pays for allowed for 2 weeks time to file affidavit. This is the
Very obliged, Lordship.
28.
Wait, please, Your Lordship.
Yes.
Your Lordship, I have already filed my affidavit, Your Lordship, bringing on record the service of notice, Your Lordship, on the respondent number 5 and 6.
5 and
Your
6, they've been served.
Yes, Your Lordship, it has been delivered, Your Lordship.
MS Tian Marak submits that.
Your Lordship, LD Sangma, Your Lordship. LD Sangma.
Oh, sorry. Yes, MS submits that affidavit of service has been filed with regard to service of notice, indicating the factum of service on respondents 1, 5 and 6. Stop. Yes, Mr.
I will pray for 3 weeks time, my Lord, to file my affidavit.
Next, Mr. SD prays they will allow 3 weeks time to file affidavit. Only it's a matter of 3 weeks for affidavit for appearance or respondent 5 and 6.
Hello, Lordship.
29.
Give me matter has become infructuous, my Lord, this matter. My Lord, may kindly consider this letter.
Yes. Elections have been held.
No, my Lord. Here, my Lord, spot inquiry. Once there is a claim that there should be an election from one party, my Lord, we have asked for spot inquiry, my Lord, and this is on the process, my Lord. And they are very much aware, my Lord. Kindly see, my Lord, the letter when it was issued, my Lord, on 2nd of August.
The file is when?
I'll supply a copy to them also. And they have received a copy also, my Lord.
What do you have to say?
1 week time, Your Lordship. Because
Yes?
1 week time, Your Lordship.
About letter, 1 week time. What do you have to say about the letter?
Because the conducting senior, he is out of station, Your Lordship.
1 week time is already gone from 2nd August. Mr. SD today has produced a letter dated 2nd August 2023, wherein it indicated that a spot inquiry has been ordered by the revenue officer, GHADC, with regard to the public of Maula Kandi, MAULA again, demanding for election. What happened to the report? Now, second, you should have the report.
Yes.
When are you going to have the elections?
My Lord, now the inquiry is going to be, sorry, my Lord, this inquiry has been held, or it is about to be finished, my Lord, inquiry. Thereafter, the inquiry report will be placed before the EC.
Yes.
Then it is the EC who will decide.
That person to spot inquiry, stop inquiry report will be published, will be
placed, my
will be placed before the EC who will take a decision with regard to the conduct of elections to elect a new Gombora of Maula Kandi village. Stop. However, as what's your name?
E Pajo. E Pajo.
A little louder.
E Pajo.
Yes, however, as MS Ibajo, on behalf of the petitioner, expresses her difficulty due to the absence of senior, this is matter of tomorrow for the orders. We'll finish it off. No need to keep it pending. Otherwise, if he doesn't come, you are there. We'll dispose it off.
My Lord, this is the contract matter.
Yes.
Supply of the lightning conductor system to the Assam Rifles Defence My lord, we have filed our rejoinder. Now there's a new development, my lord. There's a technical bid has been opened and I've been disqualified. Now the grounds on what I've been disqualified, we are yet to find out, my lord. So can you give me a week's time, my lord, so that I'll take proper instructions as to what
for hearing.
My lord, this is for orders.
My lord, the difficulty, my lord, they are challenging certain tender conditions, my lord, saying that 40%, 60%, and our submission is that this is a supply contract, this is not a work contract, my lord. So your lordship disposed of first writ petition, my lord, allowing them to file a representation. That has been addressed, my lord. Most of the things were rectified, but they are still agreed by 1 or 2 conditions, my lord. In the meantime, they have participated in the tender, and in technical bid they have been disqualified, my lord, because they don't meet the technical criteria.
My lord,
now what they have to do is to challenge the disqualification in technical round, my lord.
My lord, that is why I am seeking, my lord, week's time, because we are yet to know on what basis, on what ground they have disqualified
Can you
us in
still
technical.
maintain writ petition then? It's over.
My lord, just a week's time, my lord, I'll take
Now
instruction.
they have to challenge the disqualification. My lord, only, my lord, they can take 1 week, 2 week, my lord, but we should be allowed to proceed with the tender, my lord. That's all.
My lord, there is an order, my lord, there is an order, already ordered by my lord.
The order is only
31st,
that
my
it is
lord.
subject to outcome of the writ.
Subject to the outcome of the writ petition, my lord. Therefore, my lord,
Subject outcome is
of this writ petition.
Where's the order?
My lord,
31st, my lord.
31st July, my lord.
31st July.
On the next page, my lord.
31st July is not the order of this court.
My lord. My lord, my only prayer, we have no problem in giving them time, my lord. Lots of grant time, my lord. Only problem, my lord, one line observation, my lord, that
It's made the final order of tender process.
I'm sorry, my lord.
The final outcome of tender process, that means you have to put additional challenge then, because the tender process already finalized now.
Fine, my lord.
Technical bids have finalized.
Yes, now financial bid.
Yes.
Only financial bid.
So therefore, my lord, a week's time, my lord, we are today. It's in the.
My lord, they have to challenge.
See, the thing is that now you're saying that you have been disqualified in technical. Bid,
technical.
That means you're not up for a financial bid. For you, this race is over. You have to go and run new race.
My lord, that I quite understand, my lord. I just need a week's time. I'll take instructions, my lord.
We'll give you 2 days time. This is a matter of Wednesday.
My lord, we should be allowed to proceed with the tender.
Wednesday. We'll
Wednesday, my lord. Wednesday, my lord.
Yes, Mr. P. Yobin submits that he has been, as per instructions, the writ petitioners have not qualified for a technical bid. So he therefore seeks that he be allowed. He prays the matter will list it on Wednesday.
My lord, if it's just a week, my lord, it's because parties are from Delhi, my lord. It'll be a little
Even
difficult.
then, we can't stall contracts and projects, Mr. Yobin, because once you stall, then once it goes in the back burner. That's why even the earlier case, I was not willing even to look at the ICDS matter. Yes,
31.
Like that.
Obliged.
Yes.
Thursday, my lord. Otherwise, that's the last.
I would be willing to come to court, but would you, since it's a holiday? Just pass it to me. Yes.
Obliged.
These are the pensionary benefit matters.
How many days?
In fact, my lord, I have been informed that the matter has been referred to the Lok Adalat, my lord.
No,
5 months.
5 months.
5 months.
5 months, yes.
Hello.
Hearing 36.
Understand? How come so fast? Yaad kariye. The matters. Channel 36, no? Yes, where's Mr. Ganguly? He's here, he's come to Shillong.
No, my lord. He was there in the system, my lord, in the morning.
Being system in the morning doesn't mean...
But here, in fact,
I'm tired of these matters.
We can have this day after tomorrow, my lord. What I was submitting, my lord, is I've gone through a Kerala High Court judgment.
It helps
the same
you.
issue, my lord. Same
Helps
issue.
you.
I don't know, my lord, but it seems that it covers the issue, my lord.
No, whether it helps you or not, that is important.
Even if it doesn't help me, my lord, it's my duty
In all
to
fairness,
point it
you
out.
place it. That's
Yes,
good.
my lord.
This matter has been adjourned, like mercilessly.
Yes, my lord. The only thing that I need to see is, my lord, whether there has been any Supreme Court judgment in that regard.
Now Supreme Court is becoming, it become like tighter and tighter. All commercial matters, they really, they frown upon any, of DRT being interfered with or any recovery proceedings, because in the ease of doing business, this is that. Mr. S. Thapar, on behalf of the petitioner, as the counsel respondent is not present, though was present earlier online, Mr. S. is directed to inform the opposing counsel that the matter be listed be listed on, we'll have it on 10th. Oh no, sorry, 10th is a Sunday. September on 11th.
11th or 12th.
Positively for hearing. Yes.
37. 37.
May I please, Your Lordship, I want to argue on only few law points, Your Lordship. Already matter was heard by Your
I
Lordship.
don't remember anything.
Your Lordship,
Because last time no one appeared on behalf of the petitioner.
no, Your Lordship, without informing me, junior of Mr. S, they short time, and I was in other court. I came rushing, but meantime it was adjourned, Your Lordship.
My lord, this matter, certain documents has been produced by the parties, my lord. So to ascertain that and to check the record, my lord, I have some time on the last occasion, my lord. However, my lord, I have not received the record. I have called for the record, my lord. So to examine the veracity of the documents that they have, my lord, filed.
It is part of record only, Your Lordship. Just get it translated.
We are allowed to access that document. Actually, there was some translation. Direction was from this court, Your Lordship, to translate some copy of the document.
For that only I have taken time, ma'am.
And then that document, I think there was an order also that all the parties are allowed to access that document, and we have gone and get the document from the registry. As per the order, they have allowed us to access the copy, and we have it. And this copy is just a minute of the meeting by the Mahari. Nothing more, Lordship. Otherwise, all the records are there. There is order for that also on the last occasion.
But are a connected matter?
This is regarding
Connected matter is against cancellation of patta by the district council, Your Lordship.
we can get it from that.
Same.
Who's the petitioner? Yeah, the
I am the petitioner, and subject matter is same, Your Lordship. I am the daughter-in-law of the.
Why you come with petition also?
Your Lordship, because while pendency of this CRP before Your Lordship, my patta was cancelled, so simultaneously this petition was filed. Because Your Lordship, patta cannot be cancelled without only on the ground that it can be cancelled on non-payment of taxes, Your Lordship. It is not that.
Patta was cancelled because there was an order from the district and judge of the district council on 11/12/2018. That order was never stayed, Your Lordship. In fact, this entire matter became infectious
But
because
still, Your Lordship,
on the basis of the
wait.
Lordship.
Relax.
Like
You drive car too fast, meets an accident. You drive in a relaxed manner. You'll get your destination safely, and you can enjoy the drive also. Not like that, right? You just drive too fast, what happens? You'll go over the cliff or you'll hit the wall or something.
That's it.
Yeah. Yes. Okay, which one will take first? I think
CRP, Your Lordship.
Okay.
CRP, Your Lordship. This
Yes.
one.
Just refresh the court's memory.
Yes, Your Lordship. Your Lordship, petitioner, this family is Sangma. She was the wife of, she was the daughter-in-law of the original patta holder, Your Lordship.
You are a daughter-in-law.
Daughter-in-law.
You are Premilish.
Yes, Pemelish Sangma, Your Lordship.
Premilish Sangma, you are the daughter-in-law.
Daughter-in-law, Your Lordship.
Yes.
Because my husband, Prince C. Sangma, he inherited the property from his mother.
Don the Patadar.
Yes, Your Lordship.
Who was the original Patadar?
Kumudini Sangma, Your Lordship.
What's the name?
Kumudini.
Kumudini.
Kumudini Sangma and her husband, Jinsen C. Sangma.
Kumudini Sangma, okay. Okay, right. What
Yes, Your
happened?
Lordship. And they have no female issue. 2 sons.
They have no?
No female issue.
Okay.
So no female issue. So son, when they become old, son look after them, and he got the property, entire property, 6 plots of land, including the agricultural land, in his name, Your Lordship.
He mutated his name.
Yes, Your
It
Lordship.
was allowed by the JCDC.
Yes, Your Lordship. It is already allowed, and thereafter, after the death of original patta holder, that is Kumudini Sangma and Jinsen Sangma, since 1993, 92, 92, this patta patta is in the name of Prince C. Sangma.
Which is your husband?
Yes, yes.
What's his name?
Prince C. Sangma.
Princeton. He's still alive?
No, Your Lordship. He died in 2014.
Oh, sorry, of course. He
Yes,
asked me.
So they are-
Died on?
Prince C. Sangma, he died in 2014. That part I will come later on, Your Lordship. So after the death of their parents, Your Lordship, they started living in the suit property, alleged suit property, Your Lordship, I must say. So they started living in this property. They are paying rent, everything, and thereafter, Your Lordship, sometime in the year thereafter, that respondent, this present Bansila C. Sangma, who is represented by learned friend Mr. P.T. Sangma, Your Lordship, she filed a case before the village court, Your Lordship, Mukdangra village court, that she was adopted in 1987 by Kumudini C. Sangma.
Bensila Sangma
Was adopted.
What is her claim? She based her claim on what?
She said that she was adopted.
By Kumudini.
Kumudini. She was adopted because since they have no female issue, she was
Claims that she was adopted.
adopted, Your Lordship.
Okay.
Adopted. But
By original
the-
Patadar.
Yes, yes.
Okay. By original
But
Patadar.
it is also alleged by the respondent that she was, after the death of the original Pattadar, she was chased away from the family.
So 87 she was adopted.
Yes, in
By
1992
Kumudini.
she was, after their death, 1990, she was chased away by the original by the
92,
present
she was chased
petitioner and her husband, Your Lordship. But since that time, Your Lordship, this petitioner and her husband, deceased husband, they were in possession of this all the suit properties.
Peacefully.
Yes, Your Lordship.
Peacefully.
They paid land revenue, and thereafter, Your Lordship, in 2000, thereafter, after the death of during the lifetime of Prince C. Sangma, this property was mutated in the name of the present petitioner.
Okay, during lifetime.
Yes, yes. During his lifetime, it was mutated, and since then onwards,
When was it mutated?
mutated in the year, Your Lordship, 1/3/2012. It is written.
Okay.
As per, because I have annexed the annexure 1, Your Lordship, as per annexure
second.
series of patta, periodic patta, Your Lordship, page 13 to
How many pattas are there?
6 pattas, Your Lordship.
The same case?
Same case, Your Lordship.
Why 6 pattas, same case? Should be 6.
But 6 parcels of land, separate, including the agricultural land also, residential plus agricultural land, Your Lordship. 6 pattas are there.
Okay.
So,
Okay, now we are clear. Yes.
now,
Now what did she do? This
So-
respondent?
So respondent in the 2000, after the death, this Prince C. Sangma, he died in 2014, Your Lordship.
Okay.
He died in 2014, and thereafter in 2015, this respondent, along with the Mahari, there was a meeting, and Mahari decided that she will be the adopted daughter, or she will inherit the property. They filed one case before the Mukdangra village court, Your Lordship, for cancellation of patta of the petitioner. It's a title suit, just LC.
Yes.
Thereafter, Your Lordship, Mukdangra village court by order dated
Damra?
Mukdangra, MUKDANGRA, Mukdangra village court, Your Lordship. It is at annexure 2, page 31 of my CRP, Your Lordship. But
Page?
page 31. Type copy is at 31, Your Lordship. So many mistakes
Did
in
he
the
take
type.
part in the title suit?
Yes, Your Lordship. Notice was issued to the petitioner, but she was not given copy of the plaint, Your Lordship. As such, she could not file any WS, or she cannot make any effective. She could not make any effective defense in support of her case, Your Lordship.
She didn't appeal against this order.
She appeared, but she was not.
She appeal against this order after.
Yes, Your Lordship.
Okay, now what happened in the order?
Sir, before I move on to appeal, Your Lordship, I beg to state that as per my learned friend is claiming that Garo customary law, daughter-in-law cannot be the inheritor of the property of mother-in-law, or had the property been transferred to the name of the son, they should have returned the land to the clan member after the death of the original patta holder. But in that, I want to say, Your Lordship, the Dorosangma's case in 1988, Your Lordship must be very aware of this, because there are 4 points to be clarified. Copy to be given, opportunity of hearing may be given.
Fundamental principle
Principle of but none of these things were followed, Your Lordship. So
no, but then you appeal. Did you?
Yes, sir, appeal.
What appeal? You said
yes,
this before
appeal.
the appellate
In the
court.
appeal, Your Lordship, I have taken the ground that in 2015, since 1993.
This order was passed on 10/12/2015.
15 and 15.
This is order of the Mukdangri village court. Okay.
Yes, Your Lordship. And Your Lordship, thereafter appeal was filed by the present petitioner before the subordinate district council court, Your Lordship.
Yes.
Subordinate district council court, Your Lordship, judicial officer, subordinate district council court, number is 4 of 2016.
Okay, then what happened?
In that case, Your Lordship, I have taken the ground that case was filed after a period of 21 years, Your Lordship. Because since 1993, we were in possession since 1993.
Okay. No. Did you take grounds with regard to the non-observance of the procedure?
Yes,
And
this was also there, yes, Your
Then what
Lordship.
was the order of the subordinate council
But
court?
learned judicial officer, Your Lordship, did not look into all this aspect, only decided the matter and setting aside the order of Mukdanga village court on the ground that law of limitation does not permit to file a suit after a period of 12 years, Your Lordship. So 1993 to 2015, Your Lordship, it is more than 20 years, Your Lordship. All these years where the respondents were, Your Lordship. So there was nothing on this record that there was that they have tried to pursue the case, or they have tried to settle the matter amicably. There is nothing on record. Thereafter, Your Lordship, this against this order passed by the learned judicial officer, they have filed.
When was the order passed, the judicial officer?
Judicial order was passed in. Just a minute. 14/7/2017.
14/7/2017 order of
order of
GO
the
of
judicial.
SDCC.
Yes, Your Lordship.
Okay.
It is in page 54 of my CRP, Your Lordship.
Set aside order of trial court.
Or trial
village
court on the ground that law of limitation does not permit for filing of a suit, Your Lordship.
That's fair enough, because this is, it's a reasonableness.
Yes, Your Lordship.
Okay. You don't
Thereafter,
liberties doesn't
against the
apply.
order, Your Lordship, my learned friend has appeared before, again file one misappeal, Your Lordship. Misappeal 7 of 17 before the judge, district council court, Your Lordship.
7 of 17.
7 of 17.
What was the order of the judge?
Judge of the order is at, Your Lordship, thereafter I filed reply, and thereafter the honorable judge learned judge was pleased to pass the order on 11/12/2018. Page 69 is the type copy, Your Lordship. 69. Miss Civil Appeal number 7 of 17, type copy is.
Yes. Order was passed on 11/12/2018.
Yes, Your Lordship.
Now this order says.
Order is a very lengthy order, Your Lordship, running
What
up
does
to.
what does it say?
Says that I am the daughter-in-law and there is no provision for.
Was evidence led at any?
No, there is no video, but he framed some issues. But Your Lordship, whether appellate, when there was no issues framed by the learned Mukdanga village court,
Did
how
he touch on the point of limitation?
Yes, he said that it is unheard of by the Garos, Your Lordship. There is, but as per Your Lordship, this larger bench of this Honorable High Court has passed one order, Your Lordship, judgment in order, with a direction that law of limitation is applicable throughout the state of Meghalaya, including the regional court. But other day, Your Lordship was fair enough, Your Lordship. Just while I was submitting, said that there is some grey areas were there. But unless the order is being challenged by anyone before any court, Your Lordship, it is binding on all the courts. Is not it, Your Lordship?
No grey areas because see in the special acts that limitation is prescribed. Even here is prescribed, I think, under that this 53 rules is prescribed.
Yes.
So, Your Lordship, unless this order is being challenged by anyone, by the...
No, that is not the larger thing. I have to go, larger thing. Is it here that the 53 rules? Where's that act? 53 act.
It is 64. Law of limitation is at 6. Law of limitation is at 6 as per this regarding this.
Where's that 53? It's not here.
It's not here.
Where's that act? I got to Johnson Sangma. Photocopy. Yes. Come on, hero. No, come on. Come on, Pizu Garola. What do you think? You? I'm just justice rules. To get you. Compilation, I'm just by Justice Sangma.
Can you see page 70 or the 75?
Kadam. Is
Page 75 is the power of the courts, village code.
This is the 53 rules.
Yes.
Yeah,
then my lord, we can see rule 19.
53 rules. 1 second. There's something wrong with the pagination. Where's the title of the rules? It's not there, see?
This title is not there. The title is not there.
See?
No, it's in the preamble only. My lord, see, chapter 1, preamble. This rule may be called as the Garo's district administration. Now, my lord, we can see rule 19.
Yes.
Page 76.
Yes.
An appeal shall lie to the subordinate district council court, additional subordinate district council court from any order or sentence passed by the village court in a criminal case or from
We're not concerned with that. We're concerned with, you see, this is the question of, not a question of limitation act per se, the question of cause of action arising when and the person's approaching the court after a long period of time. Correct?
Yes.
We're beyond the scope of like limitation law. Limitation law is a strict limitation law. Now, what I said gray area at that point of time was that's why just to show that, I said that in these statutes, special statutes, a limitation period has been prescribed. Correct? Correct.
Yes, sir.
But then that division bench judgment will address these. What happened to special statutes when limitation is prescribed and whether like limitation act will override these special statutes. So that's not there. So it doesn't matter. But in this case, your main ground is that now what is the finding of the subdivision council court? Said that limitation law is applicable.
No, he said it is not applicable because
When you went an appeal first time, he says not applicable. He says it's applicable, not applicable.
it is as far.
No, I'm not talking about the appellate order. I'm talking about the first trial, the order
They
of
did
the.
not discuss anything because I was not given copy of the plain.
No. Second rung.
Second round.
After from the village court.
She
to the,
said it is applicable.
And what are the reasons? What are the reasons she's shown there?
Reasons she has given that it is the yes, Lordship. Your Lordship may kindly come to page number 50.
No, just read. Okay.
Yes,
What
Lordship.
did she say?
She said that we cannot escape this law, central law, Your Lordship, which is.
That is also not a correct finding. Anyway, that doesn't
But she
matter.
said only law can be changed by the order of the president. Otherwise, it cannot be changed. So, law of limitation is applicable.
I think I'm afraid, Mr. Dave, we have
Yes.
to remand it back to the trial
Yes,
court.
yes. And not only
Yes.
that, Your Lordship. This
That part, she has not even decided. I've
So
seen
she has to go that part regarding first. You see on fundamentals of the trial for the village court. So we should get adequate
so
opportunity
better,
or
Your
not.
Lordship. Let it be reminded. Better.
Because
Your
otherwise,
Lordship.
subject to my friend what he submit.
No, Lordship.
But I
He will say he will come. My friend will come to that point. Daughter-in-law cannot be this as per normal rule, whatever it is.
no doubt.
See, even in the village court now, that will, but whether it will go back there. But then the thing is that on limitation, one, obstacle is that they have come to court after how many years? That's the thing.
No.
So whether you kill it here or you,
The
the thing is that she has to take the objection there.
Yes. Now the part is this. The issue, what I understand, my lord, I'm open to be corrected by my friends. Law of limitation, they have said yes, it is applicable, but they have not decided that part. First point. Second point is this. The daughter-in-law, can she inherit the property of mother-in-law? Now, in Garo customary law, it is very crystal clear that the daughter-in-law has no right. Right. If they don't have a daughter, they have to adopt. Now, that procedure, whether that procedure was correct or not, that has to be a given.
First thing, Mr. Day, you have to realize is that whether this respondents ever adopted. That
is what I was coming to.
That point has to be taken up with village court now.
Evidence.
Now he has been evidence. Like,
Yes.
whether suppose she can't just come and say one finding adopted and then you find some daughter-in-law having a pata.
That is what I was supposed to say, my lord. It has to be as per the evidence.
So it has to be on many points, but then we can't decide. Let the village court decide. So we'll put a trial court and decide all these issues.
Yes.
Like we'll bypass the village court with regard to limitation, whether it's reasonable time. Number two, whether
Patta can be cancelled. That is also one point because Your Lordship, civil court has the power. It can be village court, district council court cannot decide that.
I'm sorry, I'm not hurt you, but this is just a tentative observation of the court. You have anything?
Yes, Lordship, may I submit, Your Lordship, from the beginning, Your Lordship.
Not from the beginning, you submit from the tentative observation.
No, Lordship, everything was discussed because the judge of the district council court framed 5 issues, even including the
concern about the judge's council court. That's an appellate order.
As per the rule, Your Lordship, the division right, they are supposed to only challenge only the error of the judiciary, because everything is discussed. Even I am adopted from 1987. It is on record.
It is recorded on the justice.
Lordship, let me submit, Your Lordship. When I'm making submission, I never disturb her. It is the fair enough. Only in the court we get an opportunity.
You always disturb other counsel.
I have never disturbed.
Why you making a submission now?
See,
only her you don't disturb.
Even this is the document where they have not. She claimed that she has been paying even from the land that rent. From the record, I have even this record, even original also. For 21 years, the petitioner never paid that land revenue, that record also. This is the support, and in the meeting also they have discussed.
One thing, just listen to the court. You are advocating one thing, that firstly, daughter-in-law has no right, never paid the revenue amount or whatever what do you call it? The pata dues.
Not only that.
Never paid, and so you're a legally adopted respondent. So notwithstanding any defects in the entire proceedings that went before.
No, I'm saying because
this court will give you a decree.
No. Because on the judicial officer only on the ground there is only one say that they bring that judgment from some court from Nagaland. They're saying that that limitation is applicable. We are not saying because this one is after the death. The initiate the case. The course of action arise in the year of 2014.
Mr. Sangma, listen, we're not on facts right now. Okay, we're not on facts at all. Leave the merits of the case aside. Okay, so for a moment, just keep the merits in the corner of your mind. What the petitioners agree with is what? Suit was filed by you in the village court, correct? Now she is alleging that in the course of the suit, there was no procedure adopted.
No, there was.
Listen, Lordship. I never see. Sorry to interrupt you. Or you interrupting the court, so you don't interrupt other counsellors. Listen. Now I'm saying that's the allegation. I'm not saying it's correct or it's incorrect. Correct? Okay. She's saying that when the suit was taken up at village court, there was no procedure adopted. She was not given a copy of the plaint also. She was not even allowed to file a statement, and the judgment was delivered by the village court. Against that, she filed a appeal before the court of the subordinate council court, and that court also did not look to other things. Just said that law of limitation apply, maybe applied some judgment and allowed the appeal. Against that, you went and appealed before the judge council court. Now what he did, instead of looking within the limited, he's got this limited appellate jurisdiction to look into what was the grievance, your grievance, with regard to the order of the, of the lower court. He went and framed issues, decided that you are the rightful person who adopted. Now, suppose you put yourself in the shoes of the petitioner. Don't you feel that you've not been heard properly? No, don't you feel from the root that that a procedure has been violated? Don't you? If you are confident of your case, that means you'll go for trial.
In the village court, your lordship, in page 41, that's reflected.
They allowed enough opportunity.
The opportunity was given. An opportunity. If it is, may I read a page 41?
Can you show the written statement filed by them in the village court?
It will be there on the statement.
What do you mean it may be there?
Because they said what the parties are examined, the witness, the statement has been recorded, opportunity has been given, and after all this following the procedure, the village court has passed an order.
Your Lordship, there is
Page 41, Lordship.
Statement of the witnesses when
no, what witnesses? This is there in closing only.
Just a statement, Your
This is
Lordship,
not a
just
statement in the court.
In the last round of hearing, what documents did this court
It
asked for
was that Your
translation?
Lordship was pleased to
Why
ask
translate
a
what document?
Translator plaint, copy of the plaint. But
And
I
then
have seen copy of the plaint is also by the village court. Plaint is in the. It is not signed.
Plaint of the village court?
Yes, I'm subject to correction, Your Lordship. I'll check.
So that's why I remember this case now.
This is the record code by.
And where is the written statement of the
There is no statement, Your Lordship. I checked the record, Your Lordship.
The record's not there.
No statement, nothing. Only one Mahari in 2012, after death of this petitioner, death of the husband of the petitioner.
They might have given, but the respondent are not coming with a written statement, but their statement has been recorded.
Yes. Okay, we'll pass orders. Are you going to pass order in open court?
But I have strong objection. I have the strong objection to the reminding the matter because this.
Okay, what you seeking some time? What do you say, Mr.
No, I'm not praying for time. I have examined on the last occasion.
Yes.
There was an allegation made that I have taken time behind of her. It is just to examine the record.
No, Your Lordship, it is.
That was the submission made in the.
No submission I made
is the
on
translation correct?
Translation was correct, yes,
Translation
Your
is
Lordship.
the-
But
this
some
is-
mistakes are there. It is
Only to see the
typographical
translation.
mistake.
It is translation is done from the court, Lordship.
By the court?
Yes, court translator. It is translated with a court translator.
It is
So,
available in that record, Lordship.
It is available in the record, Your Lordship.
And whatever is meeting, it is supporting this one. It is everything is reflected even in my plane also.
Yes.
Because
This has to be decided, my lord, either by this court or by the trial court, my lord.
Let them take
It's
evidence.
limitation-
See, the thing is that
the limitation and whether the
limitation, forget limitation. We'll not go there. The thing is that let the trial court decide that also. Reasonableness, not.
Your Lordship, I maybe give some time to this because, but I have a strong objection to reminding the matter because the matter has been decided because Lordship has already appreciated since from 1987. They have adopted me. It is dispute. They never dispute in the lower court. I was adopted. They say there is no payment issue. Since I have been living with parents since from 1987 till 2015.
No, Your Lordship. It is
Not only saying the no use in the record, it speaks. From 1987 I was there.
The very fact that you're contesting that means it is evidence.
It is there. Your
How old are you? How old is your client?
Now too, I got married. Now post around 30.
Oh, you're not an old lady.
37, 30 years. Something like
So
that.
you adopted when you're a baby?
No, I was adopted since from I was at the age of 9 and 10. It is related.
87, you were 9 and 10.
Your Lordship,
So
98.
10 now, 87 now
90.
will be how old? 87 to now is how many years?
Now it will be as per the affidavit.
36 years, Your Lordship.
She said.
And 87 she was 9 years, so more than 96, 36 plus 9, 43 years old.
Here in the
It is his own admission, Your Lordship.
Is it about 40 years, he said.
And how old are you?
I am 65 years old, Your Lordship.
I'm 40 years. Here in the affidavit, page 43. Affidavit.
You're 40 years. Yes. Okay, and then you are 60 years. No, I'm just because I don't want to put parties if they're aged back to to entire process of
But what a fact, Your Lordship. May I just brief this?
Again,
Since,
giving Your
no,
Lordship.
Lordship, because fair submission should be given because yes, make a submission, I should reply to her. Because there is nothing wrong in the order passed by the village court. Village court has taken an evidence and both a party was given an opportunity and even there was even inquiry by the village court. After inquiry was done, after recording the statement of the both parties, examining the document adduced by the parties, then only the village court have passed an order. After that,
one thing, Mr. Day, we have to examine is that suppose the finding is that they came after a long period of time on reasonableness and not on being aware of the situation. If they didn't come within the reasonable time, then the presumption is that I will go against them from when the cause of action arose, like from the death of 1992. So now in that fact, that means the suit will have to be dismissed. And the suit is dismissed, where will they leave them also? Where are you staying now?
I stay separately, not in Tura, in Mukhtar, some village only. The course of action arose in the year of 2012.
After the death of
No,
not after the death. See, that Princeton Sangma, my brother, I should say, my brother was still alive.
2014 he died.
That time only, when he was still alive, the course of action take place. But by the time,
see, the thing is that anyway, I'm not making any arguments for you.
And then in the meeting, he was given some plot of land was given to him also. Plot of land was given to him also. Some land, yes, that Patta 28 was given to the son. It is in the translated copy.
Yes.
It was given to him, but the petitioner's wife, that late Princeton want to take everything, all entire property, Lordship. There is nothing wrong in the village court order, and we cannot expect the village secretary to act like a judicial officer, because they were not passing those judicial exam orders. They are just appointed by the village, by the JHTC, who are not so this one. So,
is it all right if we just remand it up to the SDCC?
Yes, that will be the appropriate forum, because appeal.
Otherwise, if remanded, then we can remand it to the village court, because Lordship.
Whatever suits my learned friend, Your Lordship.
See, remanded
No, Lordship,
because just honestly, actually by rightfully should go to village court.
Has submitted that village court, the judicial
Uneducated,
officers, yes, they are uneducated. So taking into consideration his submission, my lord, it should not be sent to the village court. It should be sent to the jury.
There is an order, Your Lordship, that CRP number 19 of 2019, where it said that where challenging in the revision, he has to see only the error of the judiciary. They have never challenged the order passed by the judicial judge of the district council court. Not even a single word where is a defect.
This is under Order 6 of the jurisdiction.
Lordship.
High Court, yes.
Because everything, even in the order, kindly appreciate, Lordship. Because she was referring to the Jori Sharma case. Everything is covered here, Lordship. Because they said even framing of issue, each and every issue has been discussed in this.
By whom? By the judge, this council court, not by the village
by
court.
By the village court, Your Lordship.
Did he take evidence at the level of the appellate court?
Appeal court.
Did he take evidence? Did the judge take evidence out of some issues? Yes, we'll pass order.
39.
Yes, hearing
38, 39 connected, Your Lordship, and that.
What about civil rule? Anything to say? I mean, the writ petition?
Writ petition, the only vote against cancellation of Bata. That will also go.
Vote it to reserve judgment.
39.
Because if that limitation law, if I'm correct, here, the only division bench said that because presidential notification is not there.
Yes.
So that's why limitation law would apply. Because nothing is there in the Reorganization Act that says that it exclude. Correct, Mr. Kanta? That's what I think division bench held. At that point of time, they said that since there's no, and the only thing that prevented, I think, was that notification of governor, 1966 notification that says that it will not apply. And so it was not applicable. But the division bench said that apply entire state of Meghalaya because Reorganization Act also does not say anything, and there's no presidential notification excluding the applicability of the. Yeah, but then
Lordship,
very because governor is the person who was the person to notify whether it should apply or not. But then presidential notification was necessary or not, that's another thing. And it's just
Lordship, I mean, just allowed to go through the judgment so that I'll.
No, Your Lordship.
Because I will just go through, then I will be able to assist the court. Because I never take. I have never. No, she has not given.
Your Lordship, I have filed affidavit enclosing this.
I will just go through. Then I will try to assist the court regarding the limitation, Lordship. Because.
Want to rehear the matter?
Your Lordship, last year, Your Lordship.
Because only giving one chance, later on that order can be passed.
I have given.
Only given an opportunity. Only once.
Let us make this into a.
Your Lordship, 22.
Lordship, because they have been taking time because they.
Okay, I will have it. Okay, since you give them a satisfaction, we'll have it on the
Monday,
12th of September for further hearing. Yes.
Lordship,
you come prepared.
Lordship,
full
much obliged, Lordship.
Yes. So you see,
much obliged, Lordship.
Mr. P.D. Sharma prays that the matter be adjourned to enable him to prepare for the.
Lordship. Much obliged, Lordship.
I'm hopeful that he can change the record, my lord.
No, Lordship. Changing. Much obliged, Lordship.
39.
So let's now board on the 12th. Give me the list. Confusion, confounded.
Yes.
The other two matters, anybody is interested? The other two other matters pending. I mean, after this matter, because it might take some time.
Yes.
43.
Yes, 1 second, yes.
I'm from the petitioner.
What was the matter about?
This is regarding the impugn order passed by the district council.
By the
bifurcation of the village, my lord.
We talk about the bifurcation, but it's not, we are agree because the impugn order.
Both of them are connected, this 40 and 44?
No, only 44, Your Lordship.
Oh, both are you, or you 44?
Yes,
What about
44. Yes.
Where's Mrs. Suna? Yes.
On the last occasion, Your Lordship.
Is that regarding that
yes.
that house?
Yes, my lord.
Who's the other side?
I'm for the state, Your Lordship.
And who's for the Pollution Control Board?
On the last occasion, my
You are party.
the last occasion, Your Lordship has directed the state respondent to produce a copy of the National Green Tribunal order.
You got it there?
Yes, Your Lordship.
You've given a copy to them.
I'll supply them a copy, Your Lordship.
Okay, just need 43. Because you relied on it, yes, it's not the next anyway. Yes. Have you supplied copies of the court?
Not yet, Your Lordship.
Okay, pursuant to order dated 23/8/2023, MS Ailingwa, then DA for State Respondent 3 has produced the order of the National Youth Tribunal dated 16/7/2022, passed in OA number 17/2016. Stop. Copy of the same is taken on board. Yes, copy. A copy of the same be given also to the opposite counsel. When do you list it then?
After a week, my lord.
Yes, this is matter.
2 weeks.
After 2 weeks, yes.
Let the copy be served to us also, my lord, so that we can.
Who are you?
I'm respond number 4, my lord.
Of course, if it must be there, then that only.
Me too.
Yes. Why you're not there in the case?
Oh, I'm not there. I asked her, I said, give me a coffee also.
Yes, no, you can get it from there.
Informative.
Yes. 44?
Yes.
44, you want to do the matter today, Mr. Walang?
With your permission, Your Lordship, let it be listed on the 12th, Your Lordship. I mean.
No, otherwise, sir.
On the 12th, Your Lordship.
Request
with the consent of the
party. But
my
12th.
my senior counsel.
Yes, sir. Yes, Mr. Lindor.
Highly obliged.
Yes.
Wait, please, Lordship.
Now let's go to.
Lordship, the details of the events of entire proceedings before the trial court.
You go and copy to him. He has been satisfied also, or he'll raise objections.
We have perused the record, Your Lordship, and in accordance of
Okay, 11/7/2019 plain file. Different influence, 769 years. Again, up to 11/9/2. Then 17/8, first appellate court calls for the records. Why?
yes, Your Lordship. May kindly refer to page number 5, Your Lordship.
No, what happened in the intervening period?
Yes, Your Lordship. They have filed a miscase.
No, that is not. You have not indicated here.
No, Your Lordship, it's in page number 5.
Of this compilation.
Yes, Your Lordship. Compilation. On 10/7/2020, they filed a miscase 55.
10/7.
Yes, Your Lordship. At page number 5, Your Lordship. They filed a miscase under 151 and enclose various documents which they are relying upon.
No, 1 second. Defendant file application addition to recall the order. This is not 17/10/2020. It's not before the appellate court.
Yes, Your Lordship, it's for recall.
No, not before appellate court.
No, not before appellate court, but they...
No, you said that. No, what happened from 10/19? Why first appellate court calls the records? Why?
Because they have filed an application under
Where's
151.
the application?
It's miscase 55 of 20.
No, they filed before the appellate court.
No, Your Lordship, they filed before the trial court.
No, I don't know why first appellate court called for the records on
Because they filed
17/8.
an appeal, Your Lordship.
That is what I would do. When was the appeal filed? Against what order?
Against the order of dismissal of the application filed under 151.
Then that should come, no, Mr. Lingno. That also chronological order is that, okay, fine. Plain file, defendant entered appearance. Then, yes, Mr. Khanumba.
Regarding this 17.
Why you have not mentioned it in this list of events?
Yes, I've already mentioned it, Your Lordship. At first instance, we filed a miscase 48, 2020. And then the court passed a mixed party order. And then after that, they filed an application under 151 to recall the order 23/6 or 23/6, 2020.
Also, you mean your list of dates goes parallel to eviction suit?
Yes, Your Lordship.
Okay. So we have to read it together. So main suit is, okay, then you go to miscase of 48.
Yes, Lordship.
Then you find this is your miscase.
Yes, Lordship. And
Okay, this is plaintiff's miscase. Right?
Yes, Lordship.
The plaintiff miscase, lower court issues status quo order. Then petitioner plaintiff file application.
For review, for definition of the status quo. For definition of the status quo, I have relied on one judgment passed by the Karnataka High Court, Lordship. In the event of any status quo, it should be defined as to what status quo should be.
Okay. Now then let's get the facts straight. So on Miss Case 48, you filed it, plaintiff, right?
Yes.
Okay. Then 2020. Then plaintiff filed application for the petition of belief, so and so to enforce the order, so and so. 24 and 21 court right to Miss Case and be heard together. Court right also party to file show cause Miss Case on 48. Non-appeared of persons, so and so, or the party applies the court application to speed trial. Non-appeared for the same as the main suit. Oh, then what about the I still.
There are a bundle of other miscases which were filed.
So that is what no missing to orders. Like I still the court's still not clear because if we have to pass the judgment, the sequence has to come very clearly.
Yes, Your Lordship.
Okay, see, trial court not the judgment order passer. The orders now. Where's the application? Where's the application filed by them for appellate court? Where you mentioned that?
I mentioned at page 6, Your Lordship.
Very confusing. Now how many miscases? There's the miscase 48. Then this
miscase 48
miscase
is still pending.
83.
83 is disposed of when they file for impleadment.
Then 55.
55 also has been disposed of, Your Lordship.
Then 35.
35 is a matter in controversy before this honorable court, Your Lordship.
Only 35.
Only 35.
We don't consider the main suit.
Only 35 because certain observation made by the appellate court, Your Lordship, it has touched into the merits of the case. And certain controversy in issue which should be developed upon framing of issues by the court has been already discussed and decided by the appellate court.
Highly confusing even your list of dates. Mr. Modi, what do you have to say about this list of events?
Your Lordship?
What do you have to say about this list of events given by them?
This is absolutely wrong, my lord.
Not absolutely wrong, but is it clear? Is it clear
I
sequence?
have made one for your lordship's convenience. Everything is here, my lord. Once your lordship will go through this,
sequence.
Everything is in sequence.
Give
All
them a
the
copy
orders,
also.
all the petitions.
Give them a copy also.
My lord, I have made only 2 copies.
Give them a copy also. Then if they agree to this one, then we can go by the paperwork. It'll be better, Mr. Nara.
Yes.
You give them, make them a copy.
Okay, lordship. Because this
give it to them.
costs 500 rupees.
Doesn't matter. 500 rupees is just not even one day's appearance for a lawyer. Yes.
Those
everything is here.
Everything is
Okay,
there, my
let's
lord,
see.
right from the beginning.
Your Lordship, even of supply of the copy, let me produce. Your Lordship, as I have stated, they have been changing counsels right from the initial stage. So there may be
It's
some-
okay. Mr. Mansoor is fair enough. He'll give you a copy. Don't worry. Even it means paying from his pocket. He's got enough. He's a very successful counsel, so don't worry about that.
My lord, everything is in sequence and paging. I have done it. Your lordship can at one glance can see the
Yes,
pages.
this is what I wanted actually, because I just want the list of events. I was getting confused last time. We got too many missed cases. What appeal was filed by them? What records were recalled? What was? I thought we could complete it today. That's why I've chased Mr. Walang away. Though he seemed happy. Yes, a compilation of the orders and the sequence of events has been filed by the parties. A paperwork by the parties. More. Mr. N. Mansoori, on behalf of the respondent, however, he made a paper book of this No, topic nahi. Both sides have filed a sequence of events with regard to the instant matters done. Mr. N. Masori, however, on behalf of respondents has submitted a detailed paper book showing the orders and showing the dates and the orders done. And a copy is made over to the court, submitted to the court. A copy of the same be given also to the lawyers for the petitioners, counsel petitioners.
Question.
If you have anything that you see at next date, we'll fix it after 1 week.
1 week.
It is a matter of 1
It
week.
will be 2 weeks, my lord.
Why, you going somewhere?
Yes.
Okay, 2 weeks. You examine it, I think it should be all right because it seems all the orders are there. So if all the orders are there, it's very convenient.
Orders are there, petitions are there, all the petitions are there.
Thank you.
Good day.